Good morning. Good morning and welcome to the District of Columbia Court of Appeals. I'm joined this morning by Associate Judge Corrine Beckwith, Associate Judge Catherine Easterly, Associate Judge Joshua Deal, Associate Judge John Howard, and Associate Judge VJ Shanker. I'm Chief Judge Blackburn Rigsby. We're here this morning in the en banc case of Morgan Banks et al. Versus David Hoffman et al. This court has granted rehearing en banc to consider a few issues, including whether the District of Columbia's Anti-SLAPP Act, strategic lawsuits against public policy, against public participation, in case you are wondering what anti-SLAPP stands for. And we're here to determine whether or not the DC Home Rule Act is violated by some of the provisions or all of the provisions of the Anti-SLAPP Act. Also being challenged are whether or not the Anti-SLAPP Act is constitutional, whether or not the parties involved in the case are public officials, whether appellants are required to prove malice to support their defamation claim, and whether appellants have met their burden of showing that the report was republished. In response to a publication of a report which addressed the question of whether the American Psychological Association colluded with the government to support torture, the appellants here, military psychologist and retired Army Colonels Morgan Banks, Deborah Donovan, and Larry James, sued the appellees here. David Hoffman, Sidley and Austin LLP, and Sidley and Austin DC, and the American Psychological Association in this court or in the trial court for defamation. The appellees each filed special motions to dismiss under the Anti-SLAPP Act, and appellants filed a motion seeking targeted discovery under the act. During the pendency of the suit, the appellants later supplemented their complaint to allege republication. In response to the special motions to dismiss, the appellants moved to declare the Anti-SLAPP Act void, arguing that it violated the District of Columbia Home Rule Act and conflicted with procedures applicable to the DC courts under Title 11, 946. The appellants further argued that the Anti-SLAPP Act contravenes the First Amendment, and the trial court denied these claims and dismissed all of the appellants' claims. A division of this court reversed and remanded, holding that the Home Rule Act precluded the trial court from giving effect to the discovery limiting aspects of the Anti-SLAPP Act. The division rejected appellants' constitutional claims and also remanded the decision to the trial court to determine whether the appellants were public officials. In its holding, the court declined to address the issue of republication, holding that the appellants were entitled to an opportunity for fuller discovery. We then granted rehearing, which brings us here today. We also granted permission to several public interest and advocacy organizations to participate as amici curiae in this matter. The counsel for the District of Columbia was granted permission to participate in this en banc argument. We granted the parties 45 minutes per side, with the counsel for the District of Columbia using 10 minutes of the argument allotted to the appellee. And I guess at this time, I'd like the parties to clarify for each side how the arguments will be divided. And I'm going to ask the appellees first, if you could just clarify how you'll divide the time and the order of the arguments of the various appellees.
Yes, Chief Judge Blackburn Rigsby. The district will go first. We'll have 15 minutes to address the Home Rule Act and constitutional issues, followed by Ms. Mendonza for the DC Council as amicus. She will address further the Home Rule Act issue. And the remaining time, 10 minutes each, will be shared by Mr. Hentoff and then Ms. Wall, focusing on the other issues in the case.
Right, thank you. And on behalf of the appellants, have you determined that you'll be dividing your time in any way? Okay. All right. With that, we welcome counsel to the podium.
Can you hear me okay?
Yes.
Is this good? Hi, thank you. Thank you, Madam Chief Judge, for that introduction. And I'm here with my co-counsel today, Mr. William. May I please reserve 7 minutes for rebuttal?
Yes. And counsel, can I just ask you to state your name for the record?
Bonnie Forrest.
All righty. Thank you.
Good morning, Your Honors, and may it please the court. Before turning to 3 clear paths that we see for reversal in this case, I would like to add just a moment or a few lines of context to what the Chief Judge just gave. 3 military psychologists were ordered to help stop abusive investigations. Yet they were accused by the defendants of colluding to continue to enable torture, including abusive sleep deprivation. The media ran with it, and headlines appeared across the world, such as psychologists who greenlighted torture. But defendants knew better. They had in their hands key military policies, government reports, and firsthand witness accounts that flatly contradicted their claims. But instead of fixing it, when we took the documents to them, they rehired HOFFMAN and then doubled down, didn't fix it, republished it, and then forced us to sue. And now they're standing behind the Anti-SLAPP Act, saying to you, trust us, we were thorough. That's not what the federal rules allow. 3 clear paths for reversal in this case. First, the Anti-SLAPP Act is void.
Is what?
Void.
In its entirety or with respect to certain provisions that allow for this procedural motion, a special motion to dismiss?
I'm not certain quite understanding your distinction there, Your Honor.
Well, we think that, as the panel did, you can sever some of the provisions and still preserve the Anti-SLAPP Act without voiding it in its entirety. And I guess I'm asking you whether that's possible, even if it may not be preferable, whether that is an option.
I think that's very difficult because, as the district conceded in their petition, if you take off the anti-SLAPP motion, there are no fees. And if you get rid of the discovery provisions, what is there? There's not much left. We will concede, Your Honor, we didn't raise the issue of severability, and your division opinion pointed that out quite clearly. But when the district raised it in their petition, we felt we could come back and say to the court, as we did, we don't think you can divide this up because we think there's no room for a Rule 12 motion here. We think it's only a Rule 56 motion because of the court's opinion in Mann that says demonstrate means more than that. So you've only got a Rule 56 motion. Take out the discovery provisions because you've got to allow discovery under the federal rules. It's not discretionary.
So
It's
counsel, let me ask you, if we believe that this in fact created a substantive right, but the Home Rule Act prevented the procedural piece of it, and the Superior Court were to adopt this procedure, or we were, depending on who had that authority, how would that change your analysis? Wouldn't the rest of the act still potentially remain if the procedure remained based on the answer you were giving?
I don't think the procedures can remain. I think the procedures are void and they go away. The DC Superior Court has never adopted them, and there's a blanket
But
prohibition.
the question is, if the DC Superior Court did adopt them?
I mean, if today they adopted them, or a year from now, after the rules-making process, Your Honor, or you
Well,
mean
the
for this
DC Superior
case?
Court began the rules-making process and paused it during the pendency of this case. And so perhaps the question is, and maybe it's not relevant to this case, you can argue that as well, but
Right.
if the procedure comes back, your point globally, not just as applied to this case, that the rest of it is void, would you still hold that view?
Let me go at it this way, because I'm not certain I'm completely tracking on the question, because I think I'm disagreeing with the fundamental premise, but let me try to go at it this way. I think in the best scenario for the district, this has got procedures and substance. I believe that the procedures are so intricately tied to the act that without them, the council wouldn't have passed it. And they say that as much in the legislative history. So if you get rid of the motion to dismiss, and if you get rid of the discovery provisions, and to answer the chief judge's question, we would be quite happy if you said, we improvidently granted, go home. Go with a division opinion, okay? If you decide just to take the discovery provisions out, right? We don't know how it works. Think about that in relation to Rule 12. And you get rid of the motion to dismiss, you can't give attorney's fees then.
I
So
mean,
what's
why
left?
can't you simply, if somebody files an anti-SLAPP Act motion, seeking attorney's fees, and the complaint can't even pass a 12B6 scrutiny, well, then they can get attorney's fees. What's wrong with that?
Because then 12B6, if you're dismissing on the basis of 12B6, but giving attorney's fees, 12B6 says you don't dismiss with prejudice. All your motions are brought at one time, all these other things. So now you've still got a new procedure that's not in the DC Superior Court rules and changes pretrial process. And it's outside and operating outside the rules and conflicts.
Can we
Sure.
get back to what I understand you think the conflict is here? At times in your brief and at times today, you seem to indicate that the conflict is between the Anti-SLAPP Act and the rules, either the federal rules or the Superior Court rules. But is that the conflict here? I thought the conflict was between the anti-SLAPP, the putative conflict is between the Anti-SLAPP Act and the Home Rule Act and the Court Reform Act, on the other hand.
All the above.
Right.
And I think your question is very helpful because what it does is it shows the different tests the court used to find conflict.
Well, let's drill down then, right? I mean,
Okay.
because if I start with DC Code 11946.
Correct.
Right, what does that statute say?
11,946.
And I'm paraphrasing it,
Apologies.
but oh, no worries. That could have sounded like a question. It was rhetorical. I paraphrase that statute as saying, we Congress are creating a new court. We understand you need some rules. Follow the federal rules unless you don't feel like it. Right? This is, we're getting you up on your feet. Go ahead and do that. That's what the Court Reform Act seems to say in 11946. That just doesn't seem like a super preclusive, exclusive, I mean, there's nothing in there about you have to follow Rule 56 of the Federal Rules of Civil Procedure, right?
No, it says you shall follow the federal rules unless this court approves a modification. And I'm paraphrasing now and taking out the
Well-
part where the DC Superior Court can actually, if it doesn't modify, actually bring in rules.
Yeah, and
that
what does
don't
it mean to modify, right? I mean, there are rules like the family court rules in Superior Court. Do those modify the federal rules? I think if you look back at our promulgation orders, when things come up to us from Superior Court, you'll find a lot of statements of, well, if we have to approve it, we do, but we kind of take no position as to whether or not we have to approve it because we're not saying whether or not this modifies. This is, family court is something that just doesn't exist in federal court. So does that modify the federal rules or is it just its own thing? All of this is to say in highly technical language, I think 11946 is a lot more loosey-goosey than appellants make it out to be.
So
Why am I wrong?
there's a lot packed in there.
Yes,
So let me
I'll give you a
start-
chance to talk now.
Okay, thank you. That doesn't mean that somebody else will, but let me start with just this issue, okay? The conflict language. Burlington talks about a conflict. and it talks about implied preemption. I think when you look at the cases like Erie Forward, the court really struggles with what.
Can we put Erie to the side for a second? Cause you
I
know,
will.
there's an argument that Erie is like doing something totally different.
But I'm
And
getting
so
there.
I just really want to
Let me
stick
land the
with
plane.
how we're interpreting the plain language of our
So it's
statute.
explicit preemption. It's we believe it's explicit preemption in direct conflict with 11.946.
But why? But, right, because
Because it
if
mandates, it says you
11.946 is just
shall-
saying, hey,
Right.
Superior Court, follow the federal rules unless you feel like you don't want to.
Right.
But I understand, and correct me if I'm wrong, you're saying that doesn't mean that the Superior Court occupies the field on all matters of procedure. That would be infeasible, right?
Those
That
are the
there
federal
is,
rules.
well, hold on, let
Yeah,
me just,
sorry.
right, I
Yeah.
think you're saying, I thought you said in your brief, if there's some overlap between procedure and substance, that as long as the overlap is just kind of incidental, then the council can enact legislation that gets into procedure, and still the Superior Court can promulgate its rules and follow the federal rules if it feels like it, and do something else if it doesn't, and maybe get this court's permission if it's considered a modification of the federal rules. Where's the conflict there?
So there's two conflicts. The first is with the mandate, because the DC Superior Court never modified their rules. They've called, and the district was asked to come to told it's advisable to go talk to the courts twice, and they didn't take anybody up on it. So that's the direct conflict. You're not following the federal rules because this is outside.
But wait,
Then you've got
I mean,
field
I
prison.
feel like you're sort of not addressing quite my question.
Okay, then I'm
Right?
not understanding.
If I understand 11.946.
Right.
Not to say everybody has to follow the rules, the federal rules. What 11.946 says is, hey, DC courts, you need rules.
Mhm.
Start with, you make the rules, you start with the federal rules, you can change them if you feel like it. You guys are the general rule makers, but that doesn't mean that you're the exclusive rule makers. And, you know, then with the Home Rule Act, the Congress says, Council, we're giving you legislative authority that has, you know, substantive authority, but is necessarily going to have some procedural authority too. And I don't hear you arguing with that, right? So the council has substantive authority and some procedural authority, and the courts have procedural authority. And so the question is like, you know, when does it get to be more incidental? When does there overlap? But the council can do its thing and the court can do its thing. And really what we're just fighting about is whether or not it's incidental. Is that fair?
So I think it's partially fair, Your Honor. I think there's, if I were a judge sitting in BANC, I'd say, Ms. Forrest, and I think this is what you're asking me, so tell me if I'm wrong. What's the gap between incidental and modification? And what does it mean if we can modify? And if it's incidental, what does that look like to substance? And my answer is first of all, in this case, you have a procedural overhaul. It modifies 8, 9, 12, probably
Well,
11.
that's conclusory, right? Like you
Right.
just said, what's the gap between modification and
Well, I'm
incidental?
getting there.
And you
I'm
just
getting there,
said,
but I'm
okay.
saying that's how wide it is. So I'm trying to show you the spectrum, right? Because you've got on one hand a procedural overhaul, which I don't think is a modification. And we cited Southwestern Bell that says, and we cited Biden, and we cited MIT, MTI, that said, you know, modification is a small thing. So the question is, would the court have the authority to approve an overall?
Right, but they're on the other side, you can't say acronyms, I can't just say full words. They're on the other side saying, no, those rules are still there, right? We didn't modify them. They're still there, you know, the Superior Court approved them. They still have them in the Superior Court rules. If you get there, great, go ahead and use them. We're doing this other earlier thing. We're filling this gap, kind of like making up the family court rules, right? Like, why is that a problem?
Because
For
it's an
home rule-
additional
for home
hurdle
rule purposes,
for home
right?
rule purposes.
right? Where the whole point of home rule was to give the council authority to legislate on issues of local concern. And what I feel like your interpretation of the statutes ends up doing is splitting the legislative authority and saying, well, the council gets some authority, but we're actually going to give the courts some like quasi legislative veto power, because if the council gets too far into procedure, the courts have to buy in and they can say, we're not doing it, which seems to be what your argument was. Hey, the courts didn't play along. They didn't bless this legislation, so they get to kill the Anti-SLAPP Act.
Go back to the purpose, which you talked about, which is you're getting.
So can you get a little closer to the microphone? I'm sorry.
Sorry.
Yeah, thank you.
Better, Your Honor. Thank you. So go back to the purpose. And yes, you've got your land leg, so to speak, right? And you're not new anymore. But I can't think, as it was clear from the correspondence in the bookshop situation, right? Judge Riley wrote a letter to the President of the United States and said, I can't think of things, various people, the correspondence went back and forth and said, I can't think of something much more fundamental than courts setting their own procedures.
But in the letter that he wrote, didn't he also express, much like Judge Easterly is expressing, that the concern here was really that we don't want the courts 18 months after this Home Rule Act starts, or 18 months after the Real Court Reorganization Act, to be subject to complete dismantling and change. And so the motivated intent behind that was really a temporary thing.
I get that was temporary, but I don't think separation of powers is temporary. And I would argue that there isn't a more and better time for courts to be very clear about what the rules are and to say, we are a check.
Let me
And we are
pick up right
independent.
on that point, because
Sure.
I think we've been talking a lot about the rules, but I think this is about two statutes.
Yeah.
We're talking about the Court Reorganization Act, which preceded the Home Rule Act. And the Home Rule Act specifically says the council shall have no authority to pass any act contrary to the provisions of this chapter, or to enact, subsection 4, any act, resolution, or rule with respect to any provision of Title 11 relating to the organization and jurisdiction of the District of Columbia courts. I don't understand what's unclear about that. I mean, that seems pretty clear. And so I feel like we're down in the weeds when we're talking about the rules, when we're really talking about two statutes and how they interact. And when you touched on the separation of powers between the role of the council and the role of the courts, I think that's where I would like to focus my question to you, to talk about why the special motion to dismiss gets right into this spot here of changing the court's rules, contrary to what the Home Rule Act says and contrary to Title 11.
Okay, sure, certainly, Your Honor. Well, as you well know by now, Mann interpreted the rule to say that it's essentially an expedited summary judgment motion. Various other decisions from this court have routinely called this a procedure.
So it's a new process or
Correct.
procedure.
And if you look at it from the perspective for a moment of the federal court, they say it's an additional hurdle, meaning since Shady Grove, and specifically in Virginia uranium, which was discussed at length in our law journal note that we cited, you've got field preemption of the federal rules. And I think that that's really clear. And basically what the court is finally comfortable saying, they took a long while to get there, I think, and they weren't clear about the analysis. But they said, we have field preemption here. And the federal rules occupy the field, and that's it. To expect that the federal court is going to bring up an exotic state procedure that isn't well thought out for a busy court, go back to your court for a minute. You're 8 judges down in the Superior Court, 2 judges down here. This was based on one case and it spawned, we brought up 44 cases, now 46. I can't think of something more important under the Home Rule Act or Separation of Powers or Court Reorganization Act, more importantly, than you being able to control your docket. and to control how the procedures work. The judge here was completely confused about how it worked, and he was on the rules committee and clearly trying. So he didn't even understand, if you look at JA 1111, if things were able to be put in the record if it wasn't through discovery.
Well, let me ask this question. When we talk about the distinction between a substantive versus a procedural act, the council has the right to pass substantive legislation. So the substance or intent behind the Anti-SLAPP Act is nothing that I have a qualm with. I think its intent is laid out, and it has an important intent. How could they do that in this kind of situation where you're suggesting that the whole statutory scheme be scrapped? Where does their substantive right to pass certain kinds of legislation begin and end in this sense?
There's a law to be had here, right? You put out a law that actually fits with the intent that they put in the legislative history, which if you speak out on an issue of public interest and you believe you're being sued because the federal rules, which is what they did here, the federal rules are being weaponized in these subsuits and they're being used to drag people through the mud. So we're going to give you a different set of procedures. And they left out the intention. They put it somewhere in the legislative history. And the statute's very clear, as this court says in Doe. So they could say, if you feel that you have been sued for an issue of public interest and being weaponized, one of the elements of an independent tort is that we're being sued to be harassed or punished for our speech. It's the first element. Then could you put in the procedures? Well, we have to look at it, but let's go to the district's brief on page 39, where they talk about the Human Sanctuary Act. Okay? That's being put into process right now. And the Depositions Act was already put in 2017.
Put into process, you mean by Superior Court rulemaking?
That's correct. It's already been put out for comments. It's in step 4. It's come back. There were no comments.
So you're
as of 2
saying that,
weeks ago.
so you're basically advocating for a cooperative process between the council and the courts in enacting essentially a rule that has both substantive and procedural elements? Or just make it an element of the cause of action itself? Is that?
Your Honor, I think that's right, because I think it's imperative, right? Nobody knows how this rule works. You're going to be litigating this for 20 more years. Rule 9 says that I can plead knowledge generally. How does this work with Rule 9 if I have to demonstrate evidence? How could I ever, Judge Steele, not meet 12b-6 under if I can plead it generally?
But
That's
I
a
mean,
great question.
So, I mean,
right?
would you agree that the district is the only jurisdiction essentially that has to jump through that sort of 2-lane process? I mean, aside from your point about the difficulties of applying different state statutes in federal court in diversity jurisdiction, putting that aside, the district, and maybe your answer is just that's the unfortunate circumstance of DC. But I mean, is that your answer?
I'm a California lawyer, Your Honor, so I can tell you that California has learned from its mistakes. And Judge McCann, who was on the division who originally split up the statute, now got en banc. And while that case didn't go forward, it's going to go forward at some point. 2 judges just made that announcement in an oral argument.
Right, but I mean,
But
but your
state
answer.
court, so for their state courts, sorry.
No, go ahead.
Yeah, the question is, I mean, I understand there are
Yeah.
myriad problems
Yeah.
with California's
Yeah.
Anti-SLAPP
Yeah.
Act statute.
Yeah.
But is there any jurisdiction that, where the legislature cannot pass one other than DC because it requires the court to implement the procedural aspects of it? I mean, I can't think of one. Certainly not in the federal system, right? In the federal system, it is true there are these eerie preemption problems. But Congress can, of course, just change the federal rules if they want to. That's part of their power. So here you're saying, but the legislature can't do that here. Only the courts can. Leaving these sort of quasi-substantive, quasi-procedural legislation to be struck through coordinated balances between courts and councils that seem, really cumbersome. And generally not my bailiwick, not where I like to spend my time. And I assume we could just pass a global rule that says we're fine with whatever the DC Council wants to do with our procedures. Generally, they don't care because procedural stuff doesn't matter that much, except when it's really sewn into substance like it is with the Anti-SLAPP Act. So is there another jurisdiction you can think of that couldn't pass an act like this?
I can only think of New Hampshire at the moment off the top of my head, and New Hampshire actually wrote the justices. And it's quoted, I believe, in Mann, where they went in and asked the justices for their opinions, and they said, no, it would violate the Seventh Amendment, and so they didn't even pass it. Now, whether they had to do that, Judge Deal, or that was a courtesy, because when you're doing something like this, you should coordinate. I don't
Well,
know the
that's an
answer to
argument that would violate the Constitution though, right? You said it would violate the Seventh Amendment?
Yeah, many
There-
states, 3 states have said anti-SLAPP acts violate. the
But not
Seventh
because it intrudes upon court procedures that only the court can pass.
Amendment.
That would be sort of a unique.
No,
I mean, again, I take it, you know,
But
as
I
Judge Shanker said, maybe that's just the unfortunate situation. But I don't think, why would Congress be contemplating that when it passed 11-946? Why isn't, what Judge Easterly says is, look, they're just trying to set up the courts. Here's some rules, try the federal rules. You want to change them? Be my guest. But nowhere in 946 is there an inkling of, and we Congress, this was before the DC Council, we Congress can't touch it because of course they could change the rules whenever they wanted to. And I don't think, now, I think you've got a perfectly good textual argument about 206.02 saying you don't get to touch any of that. I'm just not sure it makes any sense. I don't think, when they said don't mess with the organization and structure and jurisdiction of the DC courts, those sound like big picture issues. You know, don't create an intermediate court of appeals. You know, we've said what they have jurisdiction over, you can't restrict that. To get like so nitty gritty that, and don't touch on procedure because 11-946 mentions it, seems impossible to believe Congress thought about that.
I think, well, first of all, Title 11 is the code provision that embodies the Court Reorganization Act. And they weren't saying, just don't touch that procedure. They were saying, don't touch the courts. And they were clear. If you look at the McKay article on separation of powers, the goal was to
But
separate
you
powers.
concede that can't be the case, right? Like the language of the Home Rule Act, which is quite broad if you think about it from one perspective of you have no authority to enact any act with respect to any provision of Title 11. You concede that the council can enact statutes that do have some procedural elements. And I guess I just wonder, like, how do you square that textually? Right? Because it can't mean what it means. And also, you know, given the legislative history, there's no reason to think that it means literally what it means.
I
So,
think it
so on
means-
the one hand, you agree that it doesn't mean literally what it means, but then you think that it supports your argument. And I'm just trying to figure out where you ground yourself in the statute then.
I think the court has interpreted it literally. I think there is room for this court to say, and they've never
We
interpreted this.
We
11-946.
should interpret it literally.
No, I think you have interpreted.
Well, who cares what we've done before? We're here on BANC, right? Like, we're trying to figure out what the right answer
But,
is.
I mean,
And
do
I'm-
you concede what Judge Easterly said? You concede that the council can enact statutes that touch on procedures in some respect?
I think
I mean,
they
I'm not
can.
sure
I
if-
think if you wanted to throw up your hands and say, this is a procedure, you should have talked to us. We're not enforcing this, so you could.
No, but I'm saying, is it right that you have conceded in your briefing that the council can pass measures, enact statutes that touch on procedures in some way, just not too much? I don't know if you've conceded that, but I'd like the answer to that.
The answer is I haven't conceded that. What we do think is that historically you've interpreted it as incidental, and statutory stare decisis would certainly prevail. You've interpreted that statute to mean if it's incidental, that you can have it.
Well, does incidental just mean that it doesn't change? It just touches on, clarifies Judge Easterly was asking this earlier, what's your definition of incidental?
So on the one end of the spectrum, incidental would be like 28I, which is now in front of, it's in rule making, just step 4. It's on statute 13449, which is on page 39 of the district's brief. And that's an affidavit to say that you have complied and you're not filing this in compliance with the Human Sanctuary Act. And it's actually not even an affidavit as opposed to like an affidavit of merit, which is now being worked through the federal courts. It's actually you say, or your attorney says, that you're complying with this. That's incidental. There's no burden for me to be able to file my lawsuit. I don't have to go out and hire an expert and spend a lot of money.
But
It
couldn't you
doesn't change your
imagine
rules.
incidental, I mean, since we don't know what it means, I tend to agree with you that on the tech, you have a decent textual argument, you have, it's a motion, you know, it seems very procedural and what Mann says about this being basically a summary judgment motion. You know, it seems pretty like a solid textual argument, but on the other hand, when you, I can, it's not hard to imagine a forceful argument about the procedural aspects of this being substantive because it just has this feel of something the legislature, the council had a problem they were trying to fix. And it's also, while it's a special motion, it's also an act. You know, I mean, why don't we just define incidental in terms of what this kind of looks like?
Because we don't take procedures and wrap them in legislative policy goals that are outside the statute and say this feels okay.
Okay,
We
so
look at the text of the statute and what they said and what they didn't say.
if this is purely, is your argument that it's purely procedural or mostly procedural?
Purely procedural.
Purely
We,
procedural.
Judge Howard asked
Could-
me that
could-
question last time around, and I said to him, it's purely procedural.
Okay,
Yes.
could the court enact all of the procedures, promulgate all of the procedures in the Anti-SLAPP Act by court rule? Just on its own? It's purely procedural. Under Title 11, apparently, we've got exclusive procedural power. We can do that?
I think that's a tough one because it only says you can modify. And I think modify made
Why not modify?
small and
It
incremental
It
change.
imposes no substantive limitation on our modification. It just says modify if you want to.
Overhauls the federal rules. And
So,
Congress
Is
mandated
there any
use of the federal
limitation,
rules.
is there any limitation in 11-946 saying you can't overhaul the federal rules? There's nothing in there. Or point me to the language that you think that says you can't get rid of the federal rules in their entirety if you
It
feel.
doesn't say it in the rules, but it says you can modify them. Southwestern
Yeah,
Bell,
we
which
could-
we cite
could
in our
modify
briefs.
one after the other and say, yep, we're not doing that. Nope, we don't want Rule 56. We don't want 12b6. We don't want any of them. We're gonna follow Louisiana. Right? We're gonna do this totally differently. There's nothing in there that says that we can't do that. So, I mean, really, the logical import of your argument is this is totally procedural. Courts do procedure. We could recreate the Anti-SLAPP Act. And that just seems shocking to me because at the end of the day, I think this feels procedural. I mean, this feels substantive, right? That
I'm
would be,
sorry, it feels which one?
it feels substantive, right? It would be a step too far for this court to say, wait a second, we're concerned that people who are speaking out on issues of public advocacy are getting targeted by frivolous suits, right? We, the court, are gonna come in, save the day, and enact and promulgate some procedures. You think we can do that?
I think Shady Grove 403 to 404 was very clear, and that's part of the opinion where 5 justices agreed.
I didn't hear the
Pages
first part of your.
403 to 404, Shady Grove.
So I
Says
think-
very clearly, Justice Scalia says, you don't get to look outside the statute for substance.
Again,
have to look at what-
that's an eerie land, right?
No, that's the first part of the analysis, 403. That's before he gets into the second part of the analysis. That's 5 justices. And Virginia Uranium says federal rules preempt everything.
Right, but we don't have to follow the federal rules.
I
So
think you do. I think Varela, look,
show
you're
me-
sitting in
show me
BANC.
where
Varela
in
says that you do. That's the
11.946 it says
preference.
that we have to follow the federal rules.
The
So-
legislative intent for that, Varela, you could you're sitting in BANC, Judge Easterly.
Right.
You can do whatever you want. You could overrule
Right? I mean,
Varela.
the language of the statute is the Superior Court shall conduct its business according to the federal rules of civil procedure unless it prescribes or adopts rules which modify those rules.
And
Like,
you could
unless
only
you-
modify it, mean change a little.
Would you agree that at a minimum, the city council could adopt a substantive right and propose rules for Superior Court consideration? And that if Superior Court were to adopt those rules, modifying the federal rules of procedure, literally the exact same procedural rules here, and we were to vote at our Board of Judges and approve them, everything would be okey dokey?
I think that you'd have a question about whether or not you could do more than modification, given the language here. Southwestern Bell, which we cited in our brief, talked about a rate hike, right, for phone companies. And it said you can only modify. When Congress used modify, the preference was for the federal rules. And I don't think that was just to get your land legs, right? It was partially for the convenience of the bar. It was partially because that's what people were used to. But also your procedure here is really clear in the rules making. Those rules automatically come down under the Court Reorganization Act. And you have to say, yes, we're going to adopt them, or no, we're not going to adopt them. But more importantly, why would you want to just wholesale do an overhaul of the federal rules, not knowing
We
how
do
they
it quite a
work?
bit. We reject the federal rules amendments all the time. And I mean, you're
Right.
starting to make me worry that those aren't modifications. I don't think your use of the word modification, I appreciate you have a case to support it, is such a natural one. If somebody, you know, modifies their appearance to evade capture, you wouldn't think it must have been very subtle, because otherwise that wouldn't be a modification. Or if, you know, I've had a course of bad behavior and I say I've modified my conduct, you wouldn't think, well, only a little. Like, modify can be a total overhaul.
Look, I think Southwestern Bell speaks for itself. I'll refer the court again to that.
I don't think that's like trying to set forth a definitive meaning of the word modify in all circumstances. Is just interpreting one statute. And this statute of 946, 11946, nothing suggests. And by the way, I don't think we have. I think we've made things that are more than modifications under your view to the rules, including setting up whole different court systems. Nothing in 946 makes me think that by modify it means we can only barely tweak the federal rules. There's a lot of unique circumstances in DC that require like wholesale, entirely new branches of rules. The family court rules came up.
Statutory stare decisis is everyone's friend after Loper Bright, Your Honor. But let me say this. You were at the table. That's the key. You are a judicial independent branch of government.
Oh, sure. Yeah, I get that
And
alternative argument.
setting up procedures is important to your docket, controlling your docket, and saying, these are the rules. And our judges know what the rules mean, and they're carefully studied and calibrated to be fair to both sides.
But that makes me want to pivot to Judge Easterly's other question, which is, okay, I understand that we're at the table. But I heard you to answer her that you think we, by rule, could pass the Anti-SLAPP Act, which is just awesome new powers I didn't know I have. And I've got all sorts of ideas, maybe we can just, eliminate defamation suits, because I'm not a big fan of them, by creating a new procedure that, in order to even get in the court for defamation, you have to be able to prove your case wholesale. Can we do that?
If I said that, I certainly didn't
Okay.
mean to.
We can't pass a new Anti-SLAPP Act on our
I
own?
said, or I hoped I said, you can't modify and do a wholesale revamp of the procedures, which is what this is. I mean, the bottom line is that
Oh, but
this
so
sets
now,
up
but now you're,
additional.
I just want to keep these two
additional-
arguments a little bit separate. I'm sorry to interrupt. But there's sort of one thread of argument is modify needs to be minor. And I thought we had moved past that. So assume I don't buy that. Assume modifications can be major. That then when you get into the Anti-SLAPP Act, it is purely procedural. If we can do more than minor things to it, then we could pass an Anti-SLAPP Act. If I don't agree with your sort of narrow reading of the word modify, then
You and I
we as
disagree at the
a
premise.
we as a court could pass an Anti-SLAPP Act. We could pick which causes of action we wanted to create distinct procedures for, thereby elevating some, making them, really easy to prove, sinking others, making them impossible to prove, becoming, a really awesomely powerful court, which is, I'm now more interested in this argument.
You can make any procedures you want if they don't modify the federal rules. Or I should say the DC Superior Court can.
Aren't we here
And then-
because of your insistence that this is entirely a procedural issue? And I'm not sure why you have to go there. I mean, why can't you say this is both substantive and procedural, which I thought you said in your brief, but maybe I'm wrong. And to the extent it's significantly procedural, or whatever adverb you want to put in front of procedural, it has to be done through the strictures of 946. And to the extent anyone would suggest that the court could do this on its own, it's got some substantive elements that would, at the very least, and I don't mean to be planning a softball for you, I really want to know your answer to this question, but at the very least, it would implicate separation of powers questions.
I'll take that pitch.
But-
Look, that's what we think. That's exactly what we think.
But then can you answer me why you also seem to be insisting that it's entirely procedural? Is it, I mean, maybe it's because, and I don't mean to say this pejoratively, but because if the Superior Court does what Judge Howard said it might do, your clients are back here in the same position they're in
We
now.
argued below and we argued here that it's both. Our issue, and part of it's because of the procedural posture we find themselves, the court took out just the discovery. The district said it wasn't severable in its petition en banc. Okay? We fought against the petition en banc and said, no, we think it's both. Okay? We didn't say this isn't severable there. Okay? Then we came back en banc. The division opinion said, absent a severability, we're not going to talk about this. So given the district's position that you can't just take away the procedures, it goes to a point in your point to me, which is, this is front and center. The procedures are front and center here. If there is substance, and Judge Deal obviously disagrees with me, but I think the substance is located somewhere in the legislative intent, and it never got put in the statute.
You've made this point about the district conceding it in their petition for rehearing, so I'm looking at it.
Yeah.
I don't see the word severability. Could you point me to, or do they just make the point that the panel's analysis, if correct, would seem to doom other aspects of the Anti-SLAPP Act, which I would
They
agree
don't
with?
make the argument severability. They don't use the word severability, Judge Deal. What they say is that it would defeat the point of the motion if you took, I'm paraphrasing
Sure,
Mr.
sure.
Schifferle's argument. But basically, the procedures, if you take away portions of it, it's not going to give the benefit. And they said specifically with respect to the fees are only allowable by the very terms of the statute if you're awarded, if your motion is successful under the Anti-SLAPP Act, and they didn't talk about the fees on the motion of quash.
Ms. Forrest, I see that your time is running down. I know you reserved some time for rebuttal, but did you want to take a few minutes to briefly address the constitutional argument that you make and the public republication argument?
Can I briefly ask one more home rule question?
Sure,
Can we come at this from a different direction
of course.
and say the council decided, we think that allowing lawyers to do internal investigations and write these sorts of reports are really important. We think it's important for the organizations to be able to get counsel to do them. Counsel won't do them unless they feel protected. We're going to create immunity, a privilege to say you cannot be sued, right? It is internal investigation immunity. And so we're going to create that. So you just can't be sued for defamation. That takes your
All the problems
entire
away.
case off the table and you say solves all the problems.
And Judge
Right,
Kavanaugh
But
said that.
I guess my question is, why would we say that it's totally fine for the council to do the greater but they can't do the lesser, right? Like, they're actually, in this instance with the Anti-SLAPP Act, they're not saying you just can't walk into the court doors with these cases. You can get in, you just have to overcome these hurdles, you know, post 12B6, but pre-Rule 56. There, or actually, I guess maybe it's even pre-12B6. You have to survive a special motion to dismiss if one is filed, right? Why would that make sense?
If it's incident to a substantive decision that you're going to insulate tortfeasors, go for it. If it's a situation where you're
But
creating
why isn't, do you
procedures
see what I'm
that
saying? Like,
apply
it
to everybody,
seems like this is the lesser. It seems definitely incident to
it's
the,
how you do it,
okay.
how you do it, Your Honor, right? In the first instance, if they say, we're going to insulate tortfeasors, here we go. Then everybody's on notice that you're not going to sue anybody in DC, right? Because they have a substantive law insulating tortfeasors. If you simply glob on a procedure that child custody case.
Well, it's not necessarily, to change my hypo a little bit, they're not necessarily tortfeasors. It's, you know, lawyers who write reports in good faith are substantively immune.
Well, but they're
right?
not getting sued unless they're
And-
tortfeasors and somebody's alleged that something's happened.
Right,
right?
they're alleging that it's not in
Right.
good faith, right?
Right.
Yeah, but maybe they can't prove that it's not in good faith, but that doesn't mean that, I mean, you know, there's.
there is the
there's
problem
a
with the
ga- there's a-
slapstick
There's a
statute.
gap there,
Yeah.
right?
I'm going to suggest that you still have time for rebuttal and that we may have some additional questions on home rule, but I'd like you to quickly address the constitutional argument and the republication argument.
Sure, Your Honor. Let me, constitutional, I'm actually prepared to stand on our papers unless anybody has any questions about the First Amendment. Let me just talk quickly about the public official analysis and the claim by claim analysis and the actual malice, and I'll go quickly, if I may. So even if you take, even if you don't take the statute away, defendants conceded two burdens and they failed both. First, their motions weren't claim by claim as required by this court in Bronner. Sidley never claimed any protection for an expressive act. JA 449. APA asserted anti-SLAPP protection for only one publication, JA 720. I'm not adding, which would be a question of fact, the republication on the second one. B, plaintiffs are private citizens and not public officials. Defendants waived their right to contest two of the three criteria, and on the third, plaintiffs submitted 5 affidavits saying they had no policy-making authority and they were implementers. Defendants offered no evidence in response, and duties, not titles, determine responsibility for policy. In fact, they say in their motion at 451 that anybody above a major would not be a public official. Donovan, as you saw, maybe when you looked at her picture when she was at Walter Reed, at one point was a major during all of this. Finally, actual malice is a fact-laden jury question, and plaintiffs met their burden. No DOD policy permitted sleep deprivation or torture. Defendants claim they colluded to allow that in June 2005 at 2246 and 2249. The documents in their hands, military policies, one with a date circled and note on it. Jay, if you look at our complaint, it's very clear from an APA witness even. The documents in their possession, government investigations, witness statements, gave them knowledge that what they were saying was false. That is the textbook definition of actual malice. Undermanned.
So are you suggesting that we have a sufficient record to decide these factual issues or that they should be remanded to the trial court?
Your Honor, I would love it to have the brain power that I've had here this morning so far on this case, but I think you have to reverse and remand. I think that what we would like to see is discussion about what the criteria are for a public official and those 3 criteria, And then we'd also like to see, the judge lit in all our evidence except republication. And we'd like to certainly see all of that evidence. They didn't counter. And so we would like all that evidence put in under Herbert v. Landau. And on the republication, the only issue is not statute of limitations. And I can refer you again to the facts. And on rebuttal, I'll talk about that more, Your Honor. But you had two versions of the report. If they just let the link go dead, right, we would have been in much better shape and the harm would have been reduced. So we don't think on the republication, you have to even decide that unless it's because you're sitting in BANC, you want to talk about the criteria for republication on the internet. And that would make sense.
Thank you.
Thank you.
All right, and we'll reserve a few minutes for your rebuttal. Okay, so counsel for appellees.
Good morning, and may it please the court, Carl Schifferle for the District of Columbia. Like the legislatures in 35 states now, the council enacted an anti-SLAPP statute to protect against retaliatory lawsuits designed to chill free expression and political participation. The council did not violate the Home Rule Act in doing so, but used its broad legislative authority under the Home Rule Act to craft new substantive rights and remedies. This was self-government in action, addressing a matter of local concern, fulfilling the paramount purpose of the Home Rule Act. The Anti-SLAPP Act does not directly amend the rules of procedure. This targeted substantive legislation can exist.
But is that what the Home Rule Act precludes, directly amending the rules of civil procedure? Or does it preclude interference with Title VII provision, Title 11 provisions that govern the DC courts? And
The latter, Your Honor.
Doesn't it specifically say the Home Rule Act that you can't pass any laws, rules, acts? It's pretty broad, that impact Title 11.
The test would be, I agree, whether there is a conflict with Title 11, whether the council has amended Title 11 itself or passed legislation that is directly contrary to the terms.
Or rules, legislation, acts, rule. It was pretty broad.
Yes, and by rules, I think the act means regulation, the sort of what would be within the legislative
But
authority
if you,
to do so.
so if you have Rule 56, summary judgment is premature under, excuse me, Rule 56, unless all of the parties have had their discovery, right? And under the Anti-SLAPP Act, it literally allows, as Mann says, summary judgment to be granted without discovery. So how is that not a conflict? A direct conflict?
So if we're addressing whether there's a direct conflict with the rules as opposed to
Yeah.
Title 11, we don't think there is a direct conflict. The test should be one that seeks to harmonize, to give effect both to the Anti-SLAPP Act and the rules of procedure. That can certainly be done in this case. The Anti-SLAPP Act does not apply to summary judgment. It does not apply to Rule 56. Any party can move for summary judgment at any time. The Act merely supplements.
Except for parties in SLAPP cases.
Right. It is not a generally applicable rule of procedure. It addresses only a small subset of substantively defined claims. And it creates a new process, but that merely supplements the other rules of procedure.
Well, so can I go, sorry,
Go ahead, Beach.
can I go back to a premise to one of your answers now? If the council purported to actually amend federal rules of the Superior Court rules of civil procedure by saying no more summary judgment in DC, that you said there's no amendment to Title 11. But you would agree that that's an amendment to Title 11, right? To 946.
I would not agree, but I take Your Honor's concern. I don't think the council would be asserting such authority. We recognize that there is a backstop, which is that if the council action threatens the independence of the judiciary, if it usurps a core function of this court, then that would be beyond the council's authority to do.
So then we're just talking about degree again, which takes us back to the same questions we had to your friend on the other side. If the council said We think that all employment discrimination lawsuits should go to trial and should not be resolved on summary judgment. So by statute, we say that as employment discrimination cases do not, cannot avail themselves of Rule 56. Would that be okay?
Again, I would apply the principles that I just articulated, that if it did sort of threaten the independence of the court or usurp the court's core functions, I think that may be a closer question. The question would be also whether what the council is attempting to do is something that is substantive. And clearly it is so with respect to the Anti-SLAPP Act. The council in the first sentence of the committee report says the act is incorporating a substantive right. It is a right to fend off lawsuits filed by one side of a political or policy debate aimed at preventing or punishing the expression of opposing points of view.
But it's only implementing that substance by way of procedure. I mean, how else is it implementing that substance? And it could implement that substance by setting forth the cause of action and its elements in a statute that don't speak to any sort of procedural rules.
Mhm. So I think this is a substantive right that the council is seeking to establish. It may be necessary in order to.
Couple cases from our court, Public Media Lab, v. District of Columbia, Close It Title Services from 2022 and 2021 respectively, that say a special motion to dismiss is procedural. How do you square your argument here that it's substantive?
That it is still part of the substantive right. It's inextricably intertwined with the substantive right that the council has sought to create.
So it has a procedural aspect that's intertwined with the substantive aspect.
Yes, we will acknowledge that. But I think that, as the earlier colloquy indicated, the council does have the power not just to enact substantive law, but to enact law that does have a procedural aspect. When that
So my question to you is to what degree, which again, as Judge Schenker highlighted, we're kind of coming back to here. To what extent does the substance have to dominate over the procedure, or is it just that once the substantive label is fairly applied, that procedures involved doesn't matter at all?
I think what the court would look to is if there is a substantive policy objective by the legislature that goes beyond just the ordinary judicial administration, the ordinary dispatch of litigation. That is certainly the case here. 35 states have enacted an anti-SLAPP statute. They have all done it through legislation, through statute.
We
They have
don't
not
have,
done it.
we don't have, those 35 other states don't have this Title 11 or the 2602 issue, right?
True, but they do have separation of power concerns. They do have the same concerns with respect to separation of powers. They may also have either explicit or constitutional authority for rulemaking in the courts similar to 11946. And the way these courts have looked at these types of issues has attempted to harmonize the statute rather than invalidate it. One way to harmonize it, as I said, is to look, is there a substantive procedural objective beyond just the ordinary dispatch of litigation? If the answer is yes, then the statute can be harmonized with the rules. As I indicated, that it doesn't apply to summary judgment procedures whatsoever, that substantive law often requires procedures to be effective. These are not rigid categories in terms of substance and procedure. They are fluid.
The district's argument that the special motion to dismiss doesn't alter existing Rule 56 for summary judgment, and it doesn't alter existing Rule 26, for example, regarding discovery, that's true, but that doesn't seem to answer the question. What does it do? It alters and provides a whole new avenue of proceeding under our current rules that changes the impact of the overall rules. Because parties proceeding under the special motion to dismiss cannot avail themselves of Rule 56 or Rule 26. Doesn't that fundamentally change or impact the rules of procedure for the Superior Court?
No, Rule 56, to be clear, is still available to the parties. We recognize that there are discovery limiting provisions under the Anti-SLAPP Act, but under Rule 26, the court has discretion to limit discovery. So what we're looking at is not a fundamental rewriting of the rules of civil procedure. It is a supplemental process with a substantive objective. And I would like to address the point that, well, if there are procedural aspects.
Well, when you say Rule 56 is still available, explain what you mean in this context, in the anti-SLAPP context.
Sure, that as this court indicated in prior case law, that the summary judge, I believe it was Mann, that the summary judgment procedure remains available. Either party can avail themselves of summary judgment. It does not
Well, the
eliminate.
defendant can avail themselves of summary judgment if they were unsuccessful at an earlier stage of the special motion to dismiss process. But the defendant can't avail themselves of summary judgment if they were unable to meet the special motion to dismiss requirements, right?
I think,
I mean, you said it was I'm sorry to interrupt you. You said it was a these are supplemental rules, but they're only supplemental in one direction. They're not supplemental for the plaintiffs.
I think the plaintiff could move for summary judgment. It's certainly the same basis, the evidentiary basis the plaintiff would have to prevail on summary judgment would
Only
be the
if
same
they-
basis to defeat the special motion to dismiss. So I guess I don't see
But
why.
without full discovery, right?
That's true. We do recognize, well, we're not conceding that there is this sort of entitlement under the rules to full discovery. Discovery can be limited. And so for that reason, any conflict with the rules is indirect at best.
Well, I mean, if a plaintiff brings a defamation suit, defendant files a special motion to dismiss, and then it turns to the plaintiff to file this response on what's been characterized as limited discovery. And let's say the plaintiff says, I don't want to do that. I'm not in a position to do that. I decline to do that. Treat me like any other plaintiff. Consider my complaint as taken as true, proceed to discovery, and go to summary judgment or trial. Under the Anti-SLAPP Act, they'd have to be kicked out of court at that point, right?
Well, there is a provision in the Anti-SLAPP Act for targeted discovery. So that
Right, but I'm saying if they say, there's no world in which they could say, I don't want to avail myself of my opportunity to response right now. I want to be treated like any other plaintiff and go to full discovery and either summary judgment or trial. They can't do that, right? That the Anti-SLAPP Act requires that their complaint be dismissed at that point.
I mean, I take your Honor's point, right, that there are discovery limiting aspects of the act that don't otherwise exist. I don't think it fundamentally changes sort of the outcome. If the plaintiff has sufficient evidentiary basis to defeat the motion, the plaintiff's.
I'm just saying that
can
plaintiff
proceed.
is fundamentally being treated differently from any other plaintiff bringing any other tort claim. Because they have to choose whether to comply with this requirement to respond to the special motion to dismiss or to be tossed out of court.
Yes, I mean, I do agree. They do have to respond to the special motion to dismiss. But again, I don't think that creates the sort of conflict that would invalidate the council's legislative authority to act in this area. It has been acknowledged, I think, that there is the authority within the council to enact substantive law that does have some procedural effect. And I think that's particularly true where those procedures are so inextricably intertwined with the substantive right that the council is seeking to create. I did want to address an earlier point about, well, can the Superior Court through rulemaking simply fill in the gap if there is a procedural aspect that this court would not allow to take effect otherwise. And that is a serious problem because, first of all, it does mean that the court is taking on the role of judicially reviewing and approving legislation. We don't believe that under the Home Rule Act, the council's legislative authority is so limited. It also raises the question in the interim, is this act even effective before any rulemaking takes place? If there is to be rulemaking, what is the court's role? Is it making the same substantive policy determinations that the legislature is making in deciding whether to adopt the legislation through rulemaking.
Yeah, I don't get why that is. I mean, what if we just had procedural objections to it, you know? DC, so let's say, in a perfect world, this problem could have been avoided entirely. The DC council could have, sent out a note to the DC court to say, there's this issue, we don't know about 946. Maybe just adopt the Anti-SLAPP Act's provisions as part of your rules. That way it eliminates any issue. One objection you might have to that is, well, these procedures are woefully unclear. In terms of how they work, we're not going to sign on to anything that's going to drag us into a procedural mire of uncertainty and is going to require case after case to resolve. I mean, why can't we have procedural objections to the Anti-SLAPP Act? That's not a substance. That's not us injecting ourselves into the substance. That's us saying, look, we're a court. We know how to run procedures in our courts, and what you've given us through this Anti-SLAPP Act is a mess. I'm not saying it is, but just assume, like you could imagine procedural mechanisms that were a mess. And we said, we don't want any part of that. We're out. And so you're gonna have to do it without any tweaks to our procedures. You can do whatever you want substantively though.
So the procedures would be tied to implementing a substantive right. And so I don't see how one can divorce the balancing of policy concerns that reflect how best to implement this substantive right, because it still goes to the substantive issue.
No, I don't get it. I mean, so like, what if we just thought of better procedures? What if we said, look, these procedures are a mess. Here's some good procedures. If you want this act with some truncated procedures, use those. I mean, why is that necessarily a substantive judgment? I mean, I'm trying to frame it as a purely procedural one. It's not hard for me to imagine you could have purely procedural concerns.
Yes, but in order to make those determinations about this is a good procedure, this is not preferable procedure, when it is involving implementing a particular substantive right. We're not talking about generally applicable rules of procedure here. We're talking about something geared to a very specific, substantively defined set of claims and how to implement that right. That does involve making policy judgments. The council
Counsel,
chose
how's
one
that any
method.
different than when we look at any other piece of legislation and do statutory interpretation and look at the legislative history and seek to give full effect to what the council intends when we regularly interpret any other statute?
I mean, I do agree this court should be attempting wherever possible to give full effect to the council's intent. And I think the way to do that is to recognize that where there is a legitimate substantive policy objective to the legislation, that is to be given effect.
Wouldn't
There's
Superior Court
deference.
then have the duty to try to give effect to procedures the council may think is good and have to have a pretty good reason not to in that universe?
Because we're talking about a difference between simply interpreting through case law legislation versus saying that legislation is not even effective until the court takes action through
And you frame
rulemaking.
this as a separation of powers argument. And I get, we're not in a constitutional scenario. Unfortunately, we have a charter. And Congress gets to decide our separation of powers. So, what's the objection? How can we as a court say anything to how Congress decided it if the plain language says that Congress put it here? Isn't it better to say that we need to do our best to give effect to what City Council is explicitly saying they want us to do? And if City Council has a procedural proposal for the rules, Superior Court, unless it has a really good reason, should be implementing that?
So if I take your honor's suggestion that the court would be performing more just of a ministerial function, that it wouldn't be reassessing whether these particular provisions of the act make sense or not. We're just gonna basically ministerial act, non-discretionary, we're just gonna take them and plug them into the rules. I mean, that ameliorates some of the concern, but it then begs the question, what purpose does that serve? Why delay the effectiveness and the implementation of legislation?
Council, we've been talking a lot about sort of who has the power to do what as between the council and the courts, and in particular, starting with Superior Court. But are we forgetting the third party, maybe the elephant in the room, which is Congress, right? And I think in your brief, you said, it just can't be that when there's this overlap between substance and procedure, that it falls back to Congress to deal with the issue. But beyond sort of saying that that just can't be the case, I didn't really see much more substance for that argument. So I don't know if you want to sort of flesh that. Why can't that be? I mean, if we are, if our court system is a creation of Congress, and if our legislature is a creation of the Home Rule Act, which is enacted by Congress, then why not say that when there's this overlap, it all kind of goes back to Congress to sort out, because they have plenary power over everything.
Because I think that would violate the fundamental purpose of the Home Rule Act, which is to grant self-government to district residents with respect to matters of local concern. That's exactly what the Anti-SLAPP Act does. And it does create the real problem that we did address in our brief, that it creates, plaintiff's arguments would create this potential gap in home rule, where it is clear that Congress intended that the district government have the power to enact something like the anti-SLAPP statute. Clearly that is so. I haven't heard any contention to the otherwise, except maybe if the argument is no part of the district government can even really amend the federal rules of civil procedure, at least in any substantial respect. But setting that aside, I do think it is clear that a district government has the power to do so. And this is not something that's been reserved to Congress. And so in order for that to function, in order for home rule to be workable and to function effectively, I think it is important that we avoid creating this gap where legislation that has some procedural aspect is automatically suspect. It raises questions about, is that legislation even effective from day one? When again, the Home Rule Act grants legislative authority to the council and does not condition that authority on judicial review and approval. Conditions on mayoral approval, congressional review, but not judicial review and approval. So it creates problems from day one in terms of whether the act is effective, and then it creates all these concerns. If the court has to act, does the court have the authority to act in the substantive sphere? This court has said in Re CAP that the power under 11946 does not extend, just as under the Rules Enabling Act in the federal system, to laws that modify, abridge, or extend substantive rights. So you create not only a real concern whether the council's action is effective, but whether the court then can fill in that gap that has created through rulemaking that is of a substantive nature, intended to implement a substantive right. That is not a workable, functional system for home rule, and we would urge this court to reject that.
Right, Mr. Schifferle, we've taken you a little bit over your time, so if you want to take a brief moment to wrap up your arguments.
Of course, Your Honor, I appreciate that. I would simply ask this court to uphold the Anti-SLAPP Act. This is a critical piece of legislation. It's a critical protection for those who wish to speak out on matters of public interest. And this
Can we
protection,
uphold certain provisions of the Anti-SLAPP Act without upholding the entire act? Or are the provisions severable in your view?
if absolutely necessary to save some provision of the act, we would say yes. But we want the court to recognize that by eliminating the discovery limiting provisions, that it is a severe curtailment of the Anti-SLAPP Act. It does gut sort of a central aspect of how the substantive right is protected. And this is an important protection here in the nation's capital, in the district, all the more important that the right to express oneself freely and participate in political affairs without retaliation is absolutely critical. I did want to refer to because we didn't touch really on the real world impact of the anti-SLAPP statute, I would refer the court to the amicus briefs that were filed by a range of public interest advocacy organizations, and also the brief by the National Women's Law Center and other groups explaining how these protections are critical to those who have suffered sexual harassment, anti-gender violence. The plaintiff's arguments, as I said, would gut the act. We asked the court.
So I'm sorry, I know you were wrapping up,
Yeah.
but I mean, doesn't our answer on severability, and I realize you're in a tough position because you had to answer the question, but answer on severability really goes to the whole question here, which is that if the discovery limiting principles are cut out of the statute, they defeat the entire purpose of the statute. Doesn't that just go to show that the procedural aspects of this, the discovery limiting principles, discovery limiting provisions are the driving force of the entire substance of the Anti-SLAPP Act?
We do acknowledge, yes, they are important to the operation of the act, but that doesn't mean that the act is substantive. All it means is that in order to effectuate what the council intended, it does require procedural means. And those means, whether you want to say they are incidental or don't directly conflict with the rules of procedure or Title 11, that is perfectly permissible within the council's authority to do so. And so we would urge this court to reject the arguments that would not only gut the Anti-SLAPP Act, but cause severe collateral damage to the effectiveness and workability of home rule.
Right. Thank you, Mr.
Thank you.
Schifferle.
Good morning. May it please the court. My name is Lauren Mendonça on behalf of the Council of the District of Columbia, amicus curiae in support of appellees in this matter. The council is the district's locally elected legislature. As such, it possesses powers analogous to that of a state, and this court, from the council's inception, has interpreted limitations on the council's power narrowly so as to effectuate the paramount purpose of the Home Rule Act, which is to grant local self-governance to the district's inhabitants. In 2010, the council passed the Anti-SLAPP Act amid concerns shared by a supermajority of states around this country that litigants were using the court's procedures to suppress and harass speech. In SLAPP suits, strategic lawsuits against public participation, plaintiffs weaponize the court's procedures, and litigation itself is the harm. The council sought to immunize defendants in a subset of cases against the harms that it perceived with respect to free speech by giving them a tool, the special motion to dismiss, which allows this court to weigh the meritoriousness of plaintiffs' claims early in litigation.
Council, can I ask you, could the council, CIL, if the council substantively thought that, and I'm repeating a hypothetical that I posed to Mr. Schifferle, but that employment discrimination cases are being resolved at summary judgment too often to the detriment of employment discrimination plaintiffs whose credibility should be judged by a jury. And so in the council's substantive judgment, summary judgment should be removed as an avenue for resolution of all employment discrimination claims. Could the council do that?
So your question, Your Honor, speaks to what is the second prong of the test that the council is propounding. The first prong, which is there conflict between the council enactment and 11-946? And the second is, to the extent that the court was to find conflict, how do we harmonize that conflict? And in the second prong, we look to the separation of powers analysis propounded in Bergman and adopted by state courts around this country that have upheld legislative enactments in the face of arguably conflicting court rules. And so, and the way we get to that harmonization is if the legislative enactment, the primary purpose of the legislative enactment is to advance public policy goals as opposed to administer the court's procedure. And in so advancing the public policy goals, the legislature is not unduly interfering with the court's core functions or usurping the independence of the judiciary, then the law stands. And so to your question with respect to your hypothetical, you have articulated what would be a public policy goal that the hypothetical legislature, the council in that case, would have adopted, which is that summary judgment is proposing is a problem for in a certain subset of cases. And we made a legislative determination that in order to address that problem, we feel that they should go straight to trial. Then the second portion would be from this court's perspective, is that legislative determination interfering with the independence of this judiciary and the court's core functions? I think that as the district represented, that may be a closer case. It's not the case that we have here today at the Anti-SLAPP Act, but I would contend that probably yes.
So that, I mean, that makes a whole lot of sense to me as an interpretation of 11-946. Is there, I mean, I know not interpreting 11-946 But is there anything that you could point me to that you think sort of lays out that analysis? Is there a state court that sort of says the same thing? It's like, well, this legislative enactment, we might balk at it if it were trying to administer our courts, but here what they're really doing is getting at a policy enactment. And so that's in bounds. Is there, so other than your brief, what would you point me to as the best articulations of that position?
I think that there are several state Supreme Courts that's decisions embody that articulation. Mellowitz State from Indiana comes to mind. Antero from Arizona comes to mind. I'm sorry, Antero's from Colorado. We have Seisinger v. Siebel, which is Arizona. So I think any three of those, I think my favorite is probably Mellowitz because it incorporates a discussion of the Anti-SLAPP Act, but.
I'm an Arizonan, so I'm going with that.
There you go. Yeah, so I think that this is a well-supported standard throughout this country that would allow this court to resolve the issue.
So is that, excuse me, so is that how you would frame incidental? That incidental just means that because there's a strong policy goal, a substantive goal, that it's not really the degree of procedure that we're creating this really explicitly procedure-driven thing. Because it is infected with substance, the procedure then becomes incidental.
Yes, incidental to the extent that, again, it's not usurping a court function. And I think really the incidental is really looking at what role is the law that the council has passed of how is it affecting the independence of the judiciary or interfering with the court's core function.
So help me understand a little more from Judge Shanker's question, why that's a closer question than anti-SLAPP. If we look at it from the view, and I get the point that's been raised already, that the special motion to dismiss does not eliminate Rule 56 from being existent should someone survive it, but the special motion to dismiss completely flips the burdens and limits discovery, and in most cases, I imagine, probably eviscerates someone's ability to get to Rule 56. How is that not a stronger setting of the deck and changing of things than just eliminating Rule 56 and forcing things to trial?
Sure. Well, as the court noted in Mann, and I understand that your honors have had some difficulty squaring this. However, it is the case that Rule 12 continues to exist, Rule 56 continues to exist to the extent that a defendant is moving for dismissal under the Anti-SLAPP Act. They get a second bite at the apple under 56, or another bite under Rule 50. And again, sure, the burdens are flipped. I don't think that that is necessarily a problem. This court has always taken a narrow reading of limitations on the council and has never applied, as appellants contend, a field preemption interpretation with respect to the court's rules. And so here you have the district described it as supplemental. I think it could also be described as interstitial. And the council's interstitial legislating certainly has been upheld since even before home rule.
I think I agree with our case law and your argument that we have generally done everything we can in terms of interpreting statutes to avoid infringing on the council's legislative purview. Both you and Mr. Schifferle have talked about the council's ability to pass legislation that may be in part or in whole procedural, like this special motion to dismiss, as long as it doesn't impact the quote core functions of the court. How do you define the core functions of the court apart from what's stated or in addition to what's stated in 11-946? Are you saying that that provision within Title 11 does not describe any core function of the court?
Certainly, I do think that 11-946 describes the core function of the court. I believe it's a core function of this court to, as its core function of this court and the Superior Court, for the Superior Court to use as its default set of rules, the federal rules of civil procedure. And 11-946 gives the Superior Court, with the approval of this court, the ability to modify those rules. rules. However, and so I think rulemaking, both as it's encapsulated in 11.946 and inherently, I believe, is within this court's power. Rulemaking, however, is separate from lawmaking, and the council is the district's local legislature. And here, to the extent we have conflict, it is a conflict not between the court's rules and a council-passed rule. It is a conflict, again, I don't concede conflict, but to the extent we're talking about it, it's a conflict between a council law and a court rule. And this court's precedents have clearly stated.
No, well, I think if you're looking at it as a conflict between the council's legislation and a court rule, but I guess I'm looking at it in the context of statutory enactment, creating the courts and defining one of the court's core functions as implementing its rules of procedure, which is different from drilling it down or boiling it down to just a simple court rule as opposed to a complex or bigger statute. I think we're talking about functions or lanes.
Sure, absolutely. And again, the district is, sui generis. I think we all appreciate that. Nevertheless, this court has also recognized that a standard separation of powers framework, and under that standard separation of powers framework, the legislature and the court may exercise concurrent authority. And I do not contest that the court is, in fact, I believe it is one of the court's core functions to apply the local rules of civil procedure, which 11-946 sets the default being the federal rules, and then for this court or the Superior Court to modify those rules with the court's approval. What we're dealing with, though, is the council's role. Where does the council fit in? And where the council fits into that 11-946 is when there is a public policy concern that the council sets out to address. And in this case, the public policy concern is abuse of the court's procedures by litigants. There is no remedy that can be created in the absence of a council law that addresses that harm. And so we are left with a situation, I think, as the district has ably argued, where if the council doesn't step in to redirect the burdens or rebalance the burdens, then there can be no remedy. And so when state courts have looked at this question of conflict between state legislative enactments and court rules, they've said, again, okay, what do we have here? There is an articulated legislative public policy goal. And as long as that public policy goal is not looking to, as long as the purpose of the legislative enactment is not administration of the court's procedures, is not the day-to-day operations of the court, then they are upholding the legislative enactment.
Let me ask you, some of that answer struck me as kind of odd in wording, where you were saying, we're really talking about abuse of the court's procedures. And so the city council has to step in to change the court's procedures. And so that starts to wind me around procedure again. But what I really want to know is, has the council, and I'm thinking to the example from the underlying opinion with the Debt Collection Act, where the same month the case was argued, we voted and agreed to Superior Court changing rules in line with a city council enactment, or this Human Rights Sanctuary Amendment Act of 2022. Has there ever been an instance where the council has, from the council's perspective, where there's been a problem with Superior Court or this court not adopting rules to enact its legislative enactments, modifying our own rules?
I don't know that we would view it as a problem, to be perfectly honest, because for the reasons that I've expressed, we're talking about the legislature's authority to enact laws. And from our perspective, once a law takes effect, it is the law. And if the court feels it necessary to modify its procedures to comport with the law, then we are more than happy to, as a coordinate branch, and respect that comity and appreciate that comity. But we don't believe that it's a necessary precondition. And so here,
I suppose I took Judge Howard to be asking sort of a factual question. Have you ever not found a willing party when you sought one out in the Superior Court and getting rules amendments? This kind of goes back to an
Sure,
earlier
yeah.
question that I had, which was, all of this could have been rendered moot if somebody had reached out to Superior Court. I mean, I don't know, probably would be my guess, and said, hey, why don't we see this problem in 946. We think we're right, but hey, isn't it better to be safe? If you guys wouldn't mind just going ahead and rubber stamping and just codifying the Anti-SLAPP Act as part of your rules, it would bypass a potentially significant problem. And I mean, did that outreach happen? Have you found it ineffective when you've done it in other cases?
I can't speak to all of the communications that take place between the council and the court, so answering that question factually is a bit difficult for me. However, I don't want to suggest that the court has not been a willing partner, but I do want to address what I think is the bigger issue, which is that the court adopting rules that conform with council law is not a necessary precondition to the effectiveness of council law. As the district alluded to, there are two preconditions that the Home Rule Act places on a council law being effective. The first is mayoral review. The second is congressional review. And I think it would seriously undermine the structure, the explicit structure that the Home Rule Act sets up to suggest that in order for a council law to take effect when it is dealing with arguably a matter of procedure, that we have to wait for the court to adopt that. And that is, I think, we all know that I work for a government body. I know that there is administrative delay. I think that's excusable. But, you know, when the council, I don't think there's room in the Home Rule Act really for this court or for the Superior Court to hold a council law in abeyance while it engages in the rulemaking process.
Counsel, can I just flip your attention to the Erie cases that have been cited to us that, you know, granted, I take your point and the district's point that they're answering a different question. Nonetheless, in answering that question, they seem to say that there is a direct conflict between Anti-SLAPP Act provisions, such as the ones that we have, and the federal rules of civil procedure. Can you talk to me about what we're supposed to do with that? I mean, you know, it seems like we have to acknowledge that somehow.
I appreciate the court's, what might be trepidation on behalf of the court with respect to adopting a position for the District of Columbia that is different than what the circuit has adopted. You asked me to put aside the fact that the Erie Doctrine is answering a different question than what is before the court today, but I think that's really fundamental, is that the Erie Doctrine is animated by principles of federalism, which simply are not present here. And this court has rejected broad application of preemption principles and has stated expressly, even in Varela in a footnote, that it rejected the application of the Erie Doctrine or federal courts cases sitting in diversity as an opposite, precisely because when we are looking at our local rules, which even though they derive from the federal rules, they are the local rules. And then we are looking at a local law. The question is, how do we harmonize these things? And the way that this court has historically answered that question is that the statute supersedes the rule.
But we do have cases from the Second Circuit, the DC Circuit, the 11th Circuit, all saying that cases coming up from various states located in those circuits with anti-SLAPP statutes, those statutes are in conflict with the federal rules. I guess, how do you harmonize that with what we have in 11-946?
Sure. So in Fleming, this court stated that once a federal rule becomes a local rule, it has to act like a local rule. And we are not a federal court sitting in diversity. Certainly, this court looks to the federal court's interpretation of federal rules as persuasive. However, the Erie Doctrine, which found that Rules 12 and 56 preclude the operation of the Anti-SLAPP Act, is not an interpretation of a particular federal rule. It is a doctrinal theory adopted to preserve, to avoid forum shopping and preserve equitable or maintain equitable treatment in the federal courts
Yeah,
for
but
litigants.
the ancillary question for those courts is whether there's a conflict between an anti-SLAPP provision and Federal Rules 12 and 56. Putting aside the context in which the court had to answer that question, diversity, Erie, all of that is sort of a secondary question. The ancillary question is there a conflict? And I think both Judge Easterly and the Chief Judge are asking, how do you harmonize your answer to that question with the federal court's answer to that question?
Sure, and that's why we have the second prong of our test, which again looks to is assuming there is conflict, assuming you cannot reconcile, assuming as you hypothesized, Judge Shonker, that we are amending Rule 56 here, and we are saying that Rule 56 cannot apply in Title VII cases. Then the question becomes for this court, is the animating reason behind the council's action public policy? And as long as the answer is yes, and this court doesn't find that the council in passing that law is acting in a way that interferes or usurps the court's independence, then the law stands.
That's not quite satisfactory answer to me. We always assume the best intentions of council in enacting legislation, but we often find issues or concerns with the enactment of the legislation. And so I don't think saying that just because council intended this as a public policy means of addressing a societal issue, that's the end of the analysis. I mean, I think and even if it involves a procedural rule or procedural process, that's it. We can't touch it, we can't address it, we can't view it in any way as impinging on the functions of the courts.
Again, I think this goes back to the separation of powers that this court has recognized, which is that the court has the authority, and I think, again, 11-946 fleshes out what the core function of this court is with respect to rules. And as the district argued, the court's limited in terms of its rules. Its rules must be procedural, its rules must be directed toward the conduct of the court's business. And here we have a council law that is not directed at, it's an ancillary matter. Certainly it affects the conduct of the court's business, but it is not directed at the conduct of the court's business. It is directed at the harms that particular defendants are suffering. And those are broader societal harms in the form of the chilling of free speech. So there's harms that particular defendants will suffer in the context of litigation. And then the broader societal harm that the council is trying to avoid, which is the use of litigation to suppress speech. And the way that the relationship between the judiciary and the legislature works is that the judiciary is, as Judge Teal noted, without the power to remedy those harms, but the council has that authority. And so in that instance, the judiciary's accommodates the legislative enactment.
Thank you, Ms. Mendoza.
Thank you.
Yes, finally, we will hear from Mr. Hentoff. Oh, I'm sorry. We do have one of the council. Sorry. We will hear from you as well, council.
Good morning, Your Honor, and may it please the court. I'm Thomas Hentoff with Williams and Connolly. We represent the Sidley defendants, and that's Sidley partner David Hoffman, Sidley Austin, and Sidley Austin, DC. APA's counsel, Ms. Wall, and I have a division of labor in our arguments. I plan to focus on the public official issue, the actual malice issue as it relates to Sidley, and plaintiffs' as applied First Amendment challenge to the Anti-SLAPP Act. Ms. Wall plans to focus on the Anti-SLAPP Act / Home Rule issue as it pertains to discovery, and on republication, and on actual malice as it applies to APA. So I'd like to start by turning from the argument about the validity of the Anti-SLAPP Act to how the Anti-SLAPP Act should be applied in this case. So the Sidley report constituted important speech on matters of critical public concern regarding the role of psychologists in the treatment of national security detainees during interrogations. The Superior Court held that that report qualifies as an act in furtherance of the right of advocacy on issues of public interest, thus satisfying the threshold requirement of the Anti-SLAPP Act. And the plaintiffs don't challenge that ruling on appeal. So that takes us to the plaintiff's burden under a mirror of a summary judgment standard to show that they have provided enough evidence so that a properly instructed jury.
Can I just ask a plate setting question as to how your argument is proceeding? Because, you know, how we would think about it would be might be wildly different depending on whether or not the trial court was correct that the Anti-SLAPP Act applies, or if the panel opinion is correct that in fact the discovery limiting provisions do not. Which assumption are you operating on now?
I'm operating, this argument is based on the assumption that the Anti-SLAPP Act does apply in full.
Okay, and if that's a mistaken assumption and we find that it does not apply, do you have any problem with the panel's approach of remanding because more discovery, you know, they were entitled to more discovery, so we'll punt on those questions until we figure out what the discovery shows?
Yes, Your Honor. If that's the rule, then I think a remand to continue with the anti-SLAPP motion with the guidance of the Superior Court makes sense.
Got it. Thank you.
So this takes me to two principal issues that show that the Superior Court judgment should be affirmed. The first is that plaintiffs are public officials as to whom the First Amendment actual malice test applies. And the second is, on the extensive Superior Court record, plaintiffs failed to carry their burden of demonstrating that a properly instructed jury could find by clear and convincing evidence that the defendants made false statements about the plaintiffs with actual malice. And in that regard, I'd like to address 2 points that Dr. Forrest made in her opening argument, because I think they're very, very important to how the court can and should look at the actual malice issue in this case. First, Dr. Forrest started by saying the plaintiffs were accused by defendants of colluding to enable torture. That's pretty much a quote of what Dr. Forrest said, but it's not a quote from Sidley's report. Sidley's report doesn't say that. And many judges on this court have had a lot of defamation cases. And defamation cases start with the actual statements that are being challenged, understanding them in context, and on the motion we had here, determining whether there is sufficient evidence that the defendants made those statements, knowing them to be false, or harboring subjective actual doubts that they were false. So Sidley didn't say that the plaintiffs colluded to enable torture. What the report says around page 65 is that the APA officials colluded with the DOD officials to put in place guidance for APA to put in place guidance for APA psychologists, what psychologists should do when they're supporting interrogations. That is essentially the same as the guidance for psychologists that the DOD officials, including the plaintiffs, were telling the APA officials during their conversations, this is what we have and this is what we're putting in place this is our guidance for psychologists. You should do something similar. And then the report concludes APA did do something similar. And when we look at the actual statements of the report, that's what it said. The report didn't say that in the United States government and in the US military, there are no specific rules for interrogators that specifically prohibit certain interrogation techniques. That's simply not what the report says.
Does the
And-
report say does it say or assume or imply that the Department of Defense policies include or would allow for sleep deprivation? This is one of the things your opponent is kind of focusing on, saying it actually is not the case that the Department of Defense policies allow for sleep deprivation. Is that something that is in the report from your perspective? And if so, can you talk about your client's knowledge?
Right, so the report does not say that. The report does not make statements about as of 2005 when the PENS task force was meeting. Let me just say, what's the PENS task force, right? It's the APA brought together some experts to respond to the reports of mistreatment and come up with a report that would provide ethical guidance for psychologists who are APA members. So the Sidley report does not say that the US military, the Department of Defense, had particular rules for interrogators at a particular point in time. What it said was, okay, and again, this is really important. Well, I'm going to answer that question, but I just want to say one other thing. We can look, I invite the court to look at a set of pages. I know it's a 541-page report, but there's a set of pages that make crystal clear that when Sidley said the DoD guidance was non-specific and didn't address these specific interrogation techniques, it was talking specifically about the DoD guidance for psychologists that the plaintiff banks had in draft form as 2 chapters at that time, later became medical policy. It was distributed at the PENS meeting and it was discussed. And that literally, when the report talks about DoD guidance, it's talking about that guidance. And what the plaintiffs have done is they've taken DoD guidance out of the context of the report and said, well, there's all this other DoD guidance and it's different and they're wrong. And so the court can look
Counsel,
at.
can I sort of derail you one more
Sure.
time, if you don't mind? One thing that this is kind of goes back to the prefatory question, which is if we disagree with the panel opinion, we don't have any first panel's crack at doing the analysis that you're walking us through. And one thing that we sometimes, really pretty often do in en banc is say, if we disagree with the panel and say, actually, the discovery limiting principles of the Anti-SLAPP Act do not violate the Home Rule Act, panel go back and do an analysis of public official and whether or not the trial court got it right on the merits because they skipped that by virtue of, not skipped, it was jettisoned by virtue of finding that the Anti-SLAPP Act discovery limiting provisions don't apply. Other than, I suppose there's an interest in efficiency in us just addressing it now. Do you have anything else? Do you have a view on, should we tackle all of this? Should we punt it back to a panel to let them figure it out? It sounds very not en banc worthy if this were the extent of the issue in front of us.
So speaking for my clients only, we have absolutely no issue with however the Court of Appeals wants to resolve it, whether resolving it en banc or having the panel look at it. But we do strongly feel that the record is clear. The anti-SLAPP record is clear, and it should be looked at and considered by either a division of this court or the whole court.
So counsel, you said you want us to look at a set of pages. Do you have page numbers that you would like to give to us?
I do, Your Honor. So if the court looks at, and I'll just give the page numbers from the report because I think that's a little easier. I think we know the report is the giant thing at the end of volume 2. Report pages 1 to 13, 229, and 240 show the full context about what the report was talking about when it talked about DoD guidance, okay? And then report pages 64 to 72, those are the conclusions and final thoughts. And at the beginning of that range, 64 to 72, that's where we have this couple of paragraph definition of collusion, where the report says, this is what we mean when we say collusion. Now, the plaintiffs say that Sidley accused them of criminality by using the word collusion, because that's a word that has meaning in the criminal context. If you look at the 2 paragraphs on pages 64 and 65, Sidley rejects that entirely and gives a definition that shows this is not a criminal allegation. So that's 24 pages of the report that's sufficient to give context. And then why did I say page 229 and page 240? Because that's where there's a discussion of the 2 chapters that are the DoD guidance that the report talks about. And the 2 chapters are an exhibit to the report. They're in the joint appendix. And that's what we're talking about. And that shows that the actual malice case, now that we're on appeal, it's come down to this focus of did Sidley knowingly say something false about DoD guidance when Sidley said, well, the DoD officials wanted APA to model their guidance after this guidance. And that shows that entire argument is based upon a misreading of the report. And well, my time is out, so.
Yeah, counsel, I know that your time is out. I guess if I could summarize, and you could correct me if I'm misunderstanding your arguments here, that the record is replete, in your view, with a sufficient basis to conclude there was no malice. If we conclude that the parties here were public officials, right?
That's correct, Your Honor.
Did you also want to address, you said you were going to talk about the as-applied constitutionality issue. Could you briefly address that as well?
I'd like to, Your Honor, but if with the court's indulgence, could I make one point about actual malice and one point about public official?
If you feel you must, yes.
I appreciate the court's indulgence. The second thing is just to go back to, I really want to emphasize whoever decides the actual malice issue, that as the DC Circuit said in Tabula Reyes, actual malice has to be in relation to a specific statement. And in that regard, Dr. Forrest, the second thing Dr. Forrest said in her initial argument was, headline, psychologists who greenlighted torture. That's not in the report. That's a headline from a July 10th, 2005 New York Times editorial. It's not something that the Sidley report wrote. It's actually an editorial about an article about the report. And if you actually look at the link to the article, there's a discussion in it of the infamous psychologists Mitchell and Jessen, who did torture with the CIA. So it's a good example of, you don't look at third-hand statements, you have to look at the report. That's my final point on actual malice. With regard to the public official, we show all the examples in our brief of the substantial responsibilities that each plaintiff had, overseeing other psychologists, writing policy, overseeing the protection of people who were being interrogated. And I think I can respond to plaintiff's argument very simply. Their argument is, well, we were not the policy makers. We were not the final decision makers. And the answer to that is, that's simply not the test about whether whether a government official has enough responsibilities to be considered a public official. And we need look no further than this quote from this court in Thompson v. Armstrong, which held that a a tax agent who supervised 5 to 7 people and who had access to confidential material was a public official. What this court said, quote, "The designation applies at the very least," and this court emphasized at the very least, "to those among the hierarchy of government employees who have or appear to the public to have substantial responsibility or control over the conduct of government affairs." And the plaintiff's argument only goes to the second half of that. They say they don't have control because they're not the final decision makers. Okay, but they had substantial responsibility. And now, Chief Judge Blackburn-Rigsby, with regard to the as-applied challenge, and I'm not going to talk about the facial First Amendment challenge. It's sort of a nub of the claim. It's okay, imagine that the DC Anti-SLAPP Act as applied to the world facially does not violate the First Amendment, but there's something about us. Even if the Anti-SLAPP Act facially doesn't violate the First Amendment, as applied to the plaintiffs here, it violates the First Amendment. And they say it violates the First Amendment because they didn't have all the discovery that they say they needed to respond to the anti-SLAPP motion. And a point we raise in our brief and that they don't respond to is there was a ruling by the Superior Court under the Act about how much discovery they should get. We argued against it. They argued for it. They got most of the discovery they sought. Then there was a second order, which said for case management reasons, the judge decided that the plaintiffs couldn't have 3 depositions that the court ordered. And with regard to as applied for the First Amendment, if the plaintiffs want to argue that that discovery provision is too strict, they waived that argument because they didn't appeal from the judge's order not giving them all the discovery they wanted, and they didn't appeal from the judge's order taking away the depositions. So they didn't
Appeal
give
to
this
this
court.
court? Appeal to this court?
That's right. In
And
other words,
how would that have been a permissible interlocutory appeal at that point?
well, it's not interlocutory, right? Because the case is over and they're permitted to appeal from the orders that led up to the actual order.
You
And
mean, in their ultimate notice of appeal, they didn't appeal those particular?
So it is in the notice of appeal. They noted in both orders in the notice of appeal that they planned to appeal, but then they failed to brief it.
So
So-
that's where you're saying the waiver is?
Yes.
I was wondering if there was an argument, but maybe this isn't what you were pointing out, that, they filed their complaint, there was a special motion to dismiss, there was litigation about limited discovery. Then they filed a supplemental complaint. There was another special motion to dismiss. And at that point, there was no request for discovery. So I thought maybe you were making a forfeiture argument in Superior Court, but is that not correct?
That's right, Your Honor. The waiver argument is that the plaintiffs could have said, you know what? The anti-SLAPP statute does work and it doesn't violate the Constitution. And the Superior Court abused its discretion by not giving us all the discovery they wanted.
But you don't think they had any obligation to go back after they filed their supplemental complaint and after a new special motion to dismiss was filed to say, hey, wait a second, now we need more discovery to survive this new special motion to dismiss, right? Because the court didn't grant the first special motion to dismiss, it granted the second special motion to dismiss.
I believe the court granted
Did it
both
grant both? Okay,
special motions to
that might
dismiss.
be my
So-
mistake.
So the second motion was truly supplemental. It said, here's another thing. So we basically, they weren't in conflict. And so we briefed both of them. And on the first motion, the plaintiffs sought discovery, got a lot of discovery, but not everything they wanted. And on the second motion, the plaintiffs didn't seek discovery. So there wasn't an issue in that regard.
I see. Thank you.
So that's all I have unless the court has any questions for me.
Great. Thank you. All right, Ms. Wall?
Going to say good morning, but I see we're into afternoon. So good afternoon, Your Honors. Barbara Wall, may it please the court. I'm here on behalf of the American Psychological Association. I'd like to pick up actually with Judge Easterly's question and Mr. Hentoff's comments. This is a case where the plaintiffs had absolutely full discovery, and actually the so-called limitations of discovery under the Anti-SLAPP Act were not evident here at all. In fact, this case is a textbook case of how a superior court should and could handle an Anti-SLAPP Act case. And Mr. Hentoff is absolutely correct. He stole a bit of my thunder here, which is that this issue about the discovery limitations essentially has been forfeited in two ways. First is that the plaintiffs didn't actually make this argument about the Anti-SLAPP Act discovery limitations being a violation of the Home Rule Act at all below. They only made the argument that the discovery limitations of the Anti-SLAPP Act violated the First Amendment, but they never argued below that it was a violation of the Home Rule Act. And they've waived it, as this court has already held in connection with Kahn versus Orbis.
Well, so you're limiting yourself to the discovery, you're limiting your argument, I think, to them having made an argument about the discovery limiting principles, right? But did they argue below that the Anti-SLAPP Act in general violates the Home Rule Act?
They did.
Okay, and all of you and your co-counsel have been standing here before us today saying that the discovery limiting principles are part and parcel, if not integral, to the Anti-SLAPP Act. So how can it be said that when they challenged the Anti-SLAPP Act vis-a-vis the Home Rule Act, they were not including in that the discovery limiting principles?
Because they just didn't.
But it's all together. I mean, that is the Anti-SLAPP Act, as Mr. Schifferle said, and I'm not faulting him for saying that, but because I agree with him, that is the Anti-SLAPP Act. The discovery limiting principles, without that, there is no Anti-SLAPP Act.
And moreover, the panel thought that was the case, and that's why we're here, right? So, I mean, talking about forfeiture or waiver, however you want to phrase it, whatever you want, label you want to put on it, it doesn't seem very fruitful.
Well, I would say this, Judge Easterly, the panel, when we argued this the first time around, didn't have before it the record, or at least didn't focus on the record of what happened below. And what happened below was as follows. The plaintiffs served discovery that accompanied the original complaint in August 17. It was exactly the same, and it was a document requests, deposition notices, interrogatories, just what you would expect. 6 weeks later, the defendants filed their anti-SLAPP motions. 6 weeks after that, the plaintiffs came back and they filed what they called a motion to compel discovery under the Anti-SLAPP Act and under Rule 56D. So they have said, actually, repeatedly in their papers, that they see the so-called limitations on the Anti-SLAPP Act as the same as 56, or at least what 56D would carve out if you felt something was missing. So they went ahead and they filed this motion, and the documents, all of the discovery they requested was exactly the same that they asked for originally, except they asked for 2 employee files of the 2 then plaintiffs who were APA employees. And we had about a year's worth of discovery disputes related to the requests. There were multiple hearings, there was motions practice, there was protective order, negotiating, and eventually literally a year of discovery where the Superior Court dealt with these issues. And at the end of the day, the plaintiffs got everything they asked for, except for 2 things. They didn't get all of the Sidley notes of the witness interviews. They only got 18. And by the way, those 18 were never cited or utilized or attached or even referred to in the opposition motions to the anti-SLAPP motions. So clearly, those Sidley notes were not material in terms of what the plaintiffs received. They did get, as I mentioned, two things that they hadn't asked for originally, and then there were the depositions. They originally asked for 2 depositions, then it morphed to 4 depositions, and then it went cut back to 2 depositions, then it was 3 depositions. And the court was writing all of this and the parties were negotiating all this.
I mean, counsel, we're here on BANC now. I don't like wasting my time. And, you know, my understanding is the Anti-SLAPP Act permits targeted discovery, but it doesn't require it. And we have a big fight about whether or not it can make that a discretionary call for the trial court. Now, I get your point saying, well, in exercising that discretion, the trial court largely ruled in their favor, so don't worry about it. But that's definitely not what the panel said. This case still presents the very big issue of whether or not that's even discretionary, and that's still an excellent question in this case. I mean, why would we bypass that? I mean, it seems like what you're saying is you don't need to worry about whether or not this can be a discretionary call because the exercise of discretion was in appellant's favor. But it's still a huge issue that's lingering in this case. And as an en banc court, I don't know why we would, you know, we've all gotten together. We got up early. We read a bunch of briefs. We spent a lot of time on this. Why wouldn't we go ahead and address the elephant in the room rather than sort of taking these little exit ramps that you're offering?
Well, I'm not necessarily offering an exit ramp, although if the court wants to take one as you did in Khan, you're certainly welcome to do it. What I'm saying is that this is a textbook example of how the anti-SLAPP discovery provisions do work and can be workable and don't violate the federal, the broader supposedly rules of discovery available through the federal rules.
Can I ask you this? And I wish I knew the answer. I should know the answer. Did the trial judge in denying any of these pieces of discovery requests ever reference the Anti-SLAPP Act discovery provisions, or simply say, I don't think you get this discovery period. It's overburdensome, it's duplicative, it's...
The only 2 items that the trial court denied them, one, the Sidley materials, and they said, and the court said, I don't think you need that. You have access to these witnesses, which turned out to be true. They submitted 34 affidavits and they didn't even reference the Sidley notes. The second time it happened was there was a lot of back and forth about depositions. And the Superior Court said, you already have these depositions would be cumulative. You already have something like, the court didn't number it, but you've got more than 50,000 documents, 50,000 pages that have been produced to you. What you're asking for is cumulative and burdensome. And by the way, not that I want to take up the court's time on BANC, but the depositions that were disallowed wouldn't have gone to actual malice at all. The one was a guy who said, I didn't like the way, 2 witnesses actually, I didn't like the way Mr. Hoffman conducted my interview. I didn't like that. Okay, fair enough.
Well, I know we heard from counsel for Sibley and others about the merits of the record with respect to the malice argument. But did I understand correctly that you were going to talk about some other legal issues with us?
Yes, I was going to talk also about republication.
Okay, I'd love to hear about republication.
Sure. Can I make one last point?
Of course.
Thank you. The record in this case shows that the Superior Court, which is in the business of weighing competing interests related to discovery, did exactly what it was supposed to do. It took the plaintiff's request and balanced it against what does the plaintiff need to show that it's likely to succeed on the merits. And it struck a balance. That balance was pretty much what they asked for. And They never went back and asked for reconsideration.
And therefore, no Home Rule Act violation? Is that your, that's your?
Yes, there are courts that have actually said where you've got adequate discovery, or you never even asked for discovery, then you can't challenge the Home Rule Act. There's actually a case in California, the Goldwine case, that says that. And the First Circuit and the Fifth Circuit have also said, if you got adequate discovery, they haven't challenged that. They have not briefed that in this case. They've not alleged and put before this court that there was an abuse of discretion by the trial court.
So
The,
counsel, you would agree though that as you're stating, that is not divorceable from the question that was in front of the trial court, the anti-SLAPP question, that these discovery requests were limited to what they needed to show, as you said, for actual malice and the other points that were relevant.
That's not the way the plaintiffs framed it, Your Honor. What they said is, we want this for discovery and we want this under the Anti-SLAPP Act. They put the two together. That was their choice, and the court below didn't actually make a distinction. They didn't, the Judge Puiglogu did not go through and say, well, you need this to show this, you need this to show that. That was their strategy. They alleged that this was 56D material and also under the Anti-SLAPP Act. Unless the court has further questions about this, I'll turn to republication. Publication came up in this case because the plaintiffs filed a supplemental complaint after the case had been pending for some time to address some events that had happened at APA, specifically with the APA website in August 2018. Specifically, what had happened was this. APA's website has a timeline that addresses detainee, national security detainee policy ethics issues. It's a long page, and it has dozens, even before this event, it had more than 100 hyperlinks. It's mainly composed of hyperlinks where any member of the public could go look at the website and check on these links and see what it had to say. Because APA has always considered itself a clearinghouse on this issue. Events happened in August 2018. They were as follows. APA modified the timeline by adding 3 new reports. There were actually, one was a report, 2 were letters, 2 hyperlinks on the website, added a statement that said the plaintiff sued us. That was not a hyperlink. And then removed a separate landing page where the report had been lodged. And Judge Blackburn-Grigsby, I think I'll try to give you a better understanding than I did the first time around of what constitutes a landing page here. Well, we were talking about 2 separate landing pages. One was the timeline, and then there was a separate landing page that had hyperlinks to the report, the first version of the report published in July 2015, the second version of the report published in September 2015, and the 7,600 pages of supporting materials. So in August, APA got rid of the smaller landing page that only had the reports and kept the timeline with these additions. The report never changed URL. Nothing was added to the report. There was no banner. There were no bells and whistles. There was no restatement of the report in any way. At all times, the report was always available to members of the public. Afterwards, after these changes, the report was always available to members of the public. At the same time, the changes were made to the hyperlinks, to the timeline. This is all done by hyperlinks. The General Counsel of APA sent an email to the listserv of its Council of Representatives, which is its governing body. And it said, email, we have made some modifications to the timeline, and it hyperlinked to the timeline, did not point to the report. There's never been any change to
But
the
that,
report.
that email mentioned the report, right?
It said,
It-
the report is here. and
It
it-
specific, like as the only thing it was pointing out specifically. I mean, you said there's 170 things on the timeline. The only thing that the email referenced was the report as being noteworthy. Am I right?
That's almost right, Judge. Specifically, the email said that the report is, this is further related to the investigation conducted by Sidley, and it referenced the investigation. The actual language, trying to find it. So I can't do that quickly, and I know the court has had a long day already and we're not done. So I would submit that it mentioned the investigation. There was never a pointing to the hyperlink related to the report. The plaintiff's supplemental complaint at count 11 is the only time where they brought this up. This was the subject of a whole new supplemental complaint. And that was the subject of our second anti-SLAPP motion. It focused entirely on the republication issue, essentially, and the facts that went into that. Ms. Forrest said something about, oh, there's been repeated republications. Well, there were iterations of the report, but the only ones that have been at issue in this case that the plaintiffs put at issue were the report that was published in September 4th, 2015, and put on the website.
Are you aware of any cases analogous to this where a court has found that republishing or adding something to a hyperlink or a separate landing page following the initial posting of a report has constituted republication?
The cases all hold that it does not constitute republication.
Thank you.
There seemed to be a uniformity. So let's back up for 1 minute. Republication, to the extent courts have found it, are a narrow exception to the single publication rule, which has been the law of this jurisdiction since 1959. The burden is on the plaintiffs to provide a record and demonstrate to this court sufficiently if they want republication to be accepted as the doctrine of this court and found by this court to have applied here. To the extent that the panel found that there was information wanting that the court would have liked to hear about, that burden was on the plaintiffs to provide that. That was not the defendant's burden. And the plaintiffs essentially failed in that regard because the facts are undisputed here. And what I've just said are the undisputed facts. As Judge Easterly said, plaintiffs sought no discovery related to the supplemental complaint and republication. They asked for nothing. And having asked for nothing, they can't come back now and say, oh, the record is devoid of references to this. There was a declaration by the APA webmaster who set all this out that's never been refuted. The only evidence that they put into the record was they had two witnesses who said, affiants, the composition of the Council of Representatives changed. So therefore you had a quote new audience. That's not the test. If that was the test, anytime anything was directed to a group and the membership of the group changed, everything would be all up for grabs again. A couple of other.
Thank you, Ms. Wall. Are these additional points related to republication?
Yes, I just
Very
wanna-
briefly, please.
Very briefly, Your Honor. Thank you. The plaintiffs have said erroneously, and I think this is very important, that republication is a question of fact. It is not. In fact, courts have said that it is very clearly a question of law. And the plaintiffs cite to the Tavula-Reyes case, saying it's a question of fact. They misquote that case. Actually, the question there was, whether an individual was responsible for publication of the allegedly defamatory material. In fact, it had nothing to do with republication. A number of cases have said quite the opposite, that republication is a question of law for the court.
All right, thank you so much, Ms. Wong, for your arguments today. We've reserved a few minutes for rebuttal, Ms. Forrest.
Thank you very much, and thank you for your attention. I know it's been a long morning. I want to make 3 quick points on the first issue and then go to actual malice and a few quick points on discovery, and I'll try to be as brief as possible. So please interrupt me. I'm going to try to go a little bigger picture, but get into actual malice a little bit because my friend across the table did. So let's start here. Chief, I think the initial question, I want to pull back a minute. We got into questions, and they were all great. And I think you're struggling with what's in between incidental and modification, and we prepared for those. But I want to pull back for a moment. The initial question we think is, is there a federal rule or directive on point? And here you have several. Okay, you've got the Home Rule Act, but you've also got the Court Reorganization Act. You shall run your business according to the federal rules. And P.S. Home Rule Act. Remember what we said back there 3 years ago? We meant it. Don't mess with it. That's the way we want the courts to work. So you've got express preemption for the directive, and under Virginia uranium, the Supreme Court has said federal rules preempt the field, and that's it. No additional procedures. The Anti-SLAPP Act is new procedures. Start with there. I want to quote this quote from N. Ray Crowley. I hate to talk about the elephant in the room, and I'm sorry, as somebody who used to live here and pay taxes, DC isn't a state. And what you said in Crowley was very clear. The fact that the district has advocated for that for many years and Congress hasn't acted means it's not a high priority. I would submit, and Judge Howard, you asked if there was a problem, because if council had ever come and there had ever been a problem, they've got a bigger problem. Delegate Norton has gone to Congress twice to eliminate Clause 9, both in 21 and in 23, right after this case came down. Congress didn't pass it either time to just eliminate the exclusion. Their remedy is with Congress, and the fact that Congress hasn't acted on that other than being asked twice is problematic. Finally, I want to talk about, I think it's sort of like when you go to law school and you learn about civil procedure. I didn't get it. I got it with this case. This isn't about just procedure or substance. It's about controlling your docket. It's about authority. But quite frankly, it's also how do you navigate your way through the rules? You're awarding attorney's fees. The judge ordered us to pay discovery costs. Okay? So there was no burden on them for discovery costs. That's not the way it works. How does this work with Rule 9? I can tell you in this case, they've already said they're going to go down and make a 12B6 motion. They represented that to Judge Edelman in their first papers on other issues. Okay? You've had in Bronner, you had my colleague, Mr. Waxman, argue about what it means to proffer. That's what you're going to be faced with for years with this statute, if there isn't something done. Could you stay the case, Judge Howard, and say, go past this tomorrow? You could absolutely do that. You're sitting in BANC. Is it advisable? No. Because if you do that, it has not been studied, and there's a reason for it to go through public comment. There's a reason for it to go through the Rules Committee to understand how it works, especially when fees are allowed.
Why wouldn't it go through the Rules Committee and public comment?
It would have to.
Superior Court to pass it.
It would have to, that's what I'm saying. You couldn't just stay and say, we approve this now, is what I'm saying. We don't, obviously, you're an en banc court, you can do whatever you want. And I'm just saying, I wouldn't do that. Okay?
I thought it already went through public comment.
I'm sorry?
I thought after the panel opinion in this case.
They
there
put
was
it out
public
for comment, and nobody commented, and they
Right.
didn't pass it, they didn't.
It's gone through a public comment period, just adopting the Anti-SLAPP Act's procedures as the court's done.
Should we filed the notice, I believe we linked to the notice in our petition, Your Honor, and so it says, should we amend our rules to adopt the discovery restrictions that the court struck down? So it was weighted one way, as I recall. Okay. Public official. 2 points here, quickly. They didn't talk about pages 450 to 451 to 452. We're talking about 3 paragraphs. And in those paragraphs, one of the cases they cite deals with a public figure. Doesn't even deal with the public official. We weren't certain, and you have to anticipate defenses, if they were still just claiming public official or something else. So very scrimpy. They didn't even put their titles in that. Okay?
Sorry, I'm confused. You're looking at the,
JA 451 to
right,
452,
and what
their
document
initial
is
argument.
this?
I'm sorry?
This is, you're talking about their pleadings.
Correct.
And I thought-
Their motion.
And I thought they said that it was your burden to say what status you were claiming.
No. They conceded it was their burden to say to the court, we're public, to strip of private status.
Okay.
Okay? So things the courts have looked at, they look at duties, they don't look at rank. Everybody differed here. You had Donovan, who was a major at one point, lieutenant colonel, colonel, and they guess at that because that's never in the report. You've got her duties at Walter Reed. Well, she was doing research on breast cancer and telehealth. I'm not certain how that relates to anything in the report, but that was never analyzed, and that's part of the problem. You heard Mr. Hentoff say, we talked about collusion. They also used the term joint enterprise. Joint enterprise was a term that was coined by the Hague. And part of the goal with the report, and it was ultimately submitted as we put in our brief, was to get war crimes prosecutions. Now, let me answer your question, Judge Beckwith. And I'm gonna have to cite the language very carefully since it's been said that we didn't. JA 1240, I would refer you to, Your Honor. Key APA officials, principally the APA ethics director, joined and supported at times by other APA officials, colluded with important DOD officials to have APA issue loose, high-level ethical guidelines that did not constrain DOD in any greater fashion than an existing DOD interrogation guidelines. That's at page 9 of Mr. Hoffman's report. Again, JA 2246. Go to page 12 of Mr. Hoffman's report. Okay, the last clause in that sentence was, then existing DOD interrogation guidelines. Then existing DOD guidance used high-level concepts and did not prohibit techniques such as stress positions and sleep deprivation. Well, the problem with that is Mr. Hentoff keeps pointing you to a draft book chapter. That's at J 1883 to 1893. I have it in my hands. A draft book chapter is not existing DOD interrogation guidelines. It's not existing DOD guidance. JA 2249, page 12. Now, they said we didn't tie the report or the allegations to anything specific. Those 2 statements I just read for you, statements 5 and 17 on Exhibit A. See JA 1305 and 1312. We did that for all 3 of the main conclusions in the report. They were pulled from an Exhibit A. The judge was confused, as you can see, as 1111 about what I could submit. I tried to proffer additional affidavits at the hearing twice. He told me it was not an evidentiary hearing. Let me talk for a moment about what they had in their hands and whether it was, one more point. The draft chapter Mr. Hoffman referred to at 2466, 2477, and 2486. When he talks about that book chapter, he talks about a draft book chapter. Now, Could be he got that confused with DOD existing guidance, but that's for a jury to decide. And if there's two reasonable interpretations, that goes to the finder of fact. The policy that he ultimately is talking about in 2006 is what we call a MedCom policy or a medical command policy. Not as important as a BISCUIT, Behavioral Science Consultation Team, SOP, because the SOP ties you into the interrogation guidelines. Once
Ms.
the
Forrest,
interrogation
I have to
guidelines.
confess, I'm getting lost in the
Sure.
biscuits here.
Apologies. I
No,
apologize because I've got it.
what-
If you
what
were
do you-
going to do the
I'm
analysis.
sorry.
Yeah.
I just wanted to get a sense, you're trying to rebut their arguments on malice by saying that the evidence was insufficient. Is that?
We're saying the evidence was very sufficient. Judge Beckwith asked the specific question,
Okay.
was sleep deprivation implied or, I don't want to, I'm paraphrasing. Did you say in the report that sleep deprivation was allowed? And I gave you the page. And then the biscuit SOP says Geneva applies. Once Geneva applies, no sleep deprivation.
Okay.
Right? So on that one statement alone of the 219, once we say no sleep deprivation, there was no torture. And all of those headlines that resulted from what they said on 2246 and 2249 go away. I'll move on, Your Honor. Thank you. As far as we know, other than the Berry case, which we can't talk about because it's an unpublished opinion, we are the only ones who've ever filed a motion for targeted discovery. I talked with my co-counsel at the time. We looked at the statute together. And Mr. Free and I made a decision to go in with targeted discovery because we thought it was more credible.
After the special motion to dismiss or?
That's
after the-
correct. Rule 56D was brought in for two reasons. One, I was making the very specific argument that this conflicted with 56D. And if you look at my void and uncon motion, Judge Schenker, first out of the box, the Anti-SLAPP Act is void. We were challenging the whole act. And we always have. Now, when I filed the motions, Mr. Free and I made the decision to talk about more specifically in the motion and in each of the replies. Look, this is how it conflicts. We're showing you right here what the problem is. So we got targeted for a reason. We want, look, tell you right now, they're saying they're a thorough 148 witness interview notes. We asked for just the memorandum they prepared, right? We actually targeted that down. We want what they claim to have reviewed, 50,000, and we want the witness notes and a few depositions. Our clients can't afford a lot of money. And if we're paying for it, we certainly have to be efficient. I'm not going to bore you with what happened here with respect to the depositions. I will refer you to the record on that. We called to schedule. The judge asked me to call and schedule. Mr. Free and I, after the depositions were canceled, we gave him the deposition dates they want. In October, the judge was upset because he wanted it in September. And at that point, he said he wasn't going to come. And so I called back because there had been an ex parte call. Mr. Free and I sat down with the code, and Mr. Free said, call up and ask for an opportunity to be heard. We absolutely challenged. And the next day, my depositions were gone. I'm not certain what else I was supposed to do to challenge the situation. Finally, let me talk about republication. I'm not gonna spend my time or the court's time going through the specifics, but suffices to say, if you go to page 12 of our brief and click on that hyperlink, and it says the 7-2 report, it goes to a revised edition. They did change the URL. It goes to a new report. And that's the problem. If they had just let those links go dead, you wouldn't have July articles referring to a revised report. This was in the context of APA members saying, take it down, you rehired him. He's not coming out with a revised report. Everybody knows this has got falsities. You've admitted it. And they wouldn't take it down. They rehired him, they sat on it, and they pushed it out again and made a new motion so that we'd be subject to more fees. I would ask this court to void the act or reverse, if you choose to keep the act, reverse and remand for a determination on the public official issue, reverse and remand on negligence, and tell us what evidence is admissible to show actual malice, or you can analyze just that one statement I just gave you and the pages, and you can go to 1237 to 1251 and see all the evidence they had in their hands, military policies, government investigations, witness statements from Bryson. They say we didn't refer to him. You're right, we didn't need to, because Bo, who worked for APA, had drawn a circle around the date, and he said that in his affidavit. And the judge said, we don't get more notes, could they be redundant to complaint? Because I think it's a 12B6 standard. So we're circles. I don't expect you to analyze everything. I wanted to go back down, but I think you've got enough to at least look at the issue of sleep deprivation. They said it. Thank you for your time and attention today.
All right, thank you. We'd like to thank all counsel who argued today and submitted briefs, and also the amici who submitted briefs to this court, which we reviewed and considered, even though they were not all given opportunities to argue. With that, the court will take this matter under advisement. Thank you all for your patience and attention today.
Oh,